4 issues. The first one will be the migrant workers, the plight of Iraq and Afghanistan returnees. The second one will be why returnees should be considered and recognized by the government of Uganda. The third will be equal pay, the plight of state attorneys inside the Uganda Police Force. And then finally, we shall be honoring Mr. Malay Hassan Mabirizi Chiwanuka. We are privileged that you take your time to join us today, and we have distinguished guests before us. We look forward to a fruitful and engaging discussion. Once again, I thank you all for being part of this discussion. Our first speaker today on migrant workers and the plight of Iraq and Afghanistan returnees will be Mr. Natuhurira Enoth. Mr. Natuhurira, you're welcome.
Yes, ladies and gentlemen, good morning. Yeah, my name is Torira Enoth, Iraqi returnee, and my colleague here, Dr. Muhereza. So we'll be presenting to you our petition on the issue of 3M earplugs, Combat Earplug Settlement Program. There have been some issues of unfairness in this settlement. So join me as we go through these details. We, the undersigned, right to formally petition the Uganda Law Society, provide legal representation for Ugandan citizens who have been adversely affected by the Combat Arms Earplugs Settlement Program. This petition highlights the need for legal assistance for victims who unknowingly used the earplugs and subsequently suffered impairments to their hearing. This is the background of this case. In April 2019, a judicial panel in a multi-district litigation centralized and transferred the 3M Combat Arms Earplug, CAE in brackets, products liability litigation, MDL number 2885, to court for pre-trial proceedings before Judge M. Cassie Rogers. The related actions generally allege that the defendants' dual-ended combat arms earplugs were defective and caused the plaintiffs to develop hearing loss or tinnitus. The panel determined that these actions involved a common question of fact concerning the design, testing, sale, and marketing of the combat arms earplugs. The panel also found that centralization would eliminate duplicate discovery, prevent pretrial rulings and controversial issues and other pretrial matters, and conserve resources of the parties, their counsel, and the judiciary. As a result, in October 2023, the 3M defendant company and plaintiffs entered into a master settlement agreement, MSA in bracket, to resolve claims against the defendants concerning Combat Arms Version 2 earplugs manufactured from 1999 to 2025. They also agreed to a settlement agreement to resolve the waive cases, in bracket the waive settlement or MSA 3, in which participating claimants and their primary counsel would use a secure settlement portal set up by Brown Greer as the settlement administrator, exchange information with the settlement program. In August 2023, the parties announced that without any admission of liability, 3M Company had agreed to pay $6.1 billion to resolve the nearly 250,000 lawsuits in MDL filed by United States military service members. Military members, veterans, and commercial users, alleging combat arms earplug-related injuries from use of combat arms earplug for hearing protection. On January 9th, 2024, the parties' agreement, more especially the MSA, Master Settlement Agreement, stipulated that eligible claimants would be paid settlement awards on first in, first out, FIFO basis, and Brown Greer PLC prepared a notice outlining the FIFO procedure to effect the implementation of the payment. The condition set by the defendant was that at least 98% of the plaintiffs should be identifiable and sign the agreement, in bracket reference, Article 7, Section 7.1.2 of the settlement agreement. Otherwise, the defendant company, 3M Earplugs, in bracket, would only pay administrative expenses. That's reference, for reference, Article 3. Fortunately, with our participation, we refer to the foreign national security specialists or Ugandans, the 98% threshold participation level was hit, and later on, we were congratulated for having been eligible for the whole settlement. As mentioned above, the settlement was meant to compensate all United States military service members indiscriminately, to include the Ugandans, the permission to hold weapons and use them on the American bases. We used these defective 3M earplugs while on range in Iraq and Afghanistan. This clearly shows that we were all affected by these 3M defective earplugs. Thereafter, the set criteria for eligibility for compensation and being included on the claimant's portal was by way of subjecting all claimants to some medical procedures and audiogram tests, after which an individualized first in, first out number was issued, applications submitted, and points awarded to every claimant, depending on the results. The number of points determined how much each claimant was entitled in compensation. This was done by claimants and translated into their being successful and very expectant of compensation, for which the claimants were duly notified. While participating in the signing of the agreement, Primary Counsel advised us to opt for Deferred Payment Program, DPP, for reference Article 10, Section 2 and to 2, instead of the Expedited Payment Program, EPP, which the biggest number of us did. A payment methodology was adopted by the settlement administrator, Brown Greer, whereby the DPP claimants are awarded points derived from their reference audiogram and injury audiograms. For further and final payment, registration payment worth $1,000 each to begin with, used and dumped. To our utter surprise, after the defendant company agreed to pay $6.1 billion in compensation following the court order, The affected claimants, the settlement administrator on their own, set such conditions that were inexplicably extreme for claimants, including, among others, that originally this settlement was not including non-US citizens, leading to the discriminate exclusion of the Ugandans from participating equally in this program. Affected claimants are over 25,000, and the Ugandans are approximately, actually they are more than that, more than 3,000. Yes, these are the affected claimants, and the Ugandans are approximately 3,000 as per the list attached, but they are more than this. Yeah. This led to a number of claimants to being disqualified, so much so that, to our surprise, it later came to the attention of the affected claimants that some tests ought to have been taken or conducted within 5 years after active service and from the United States. And yet, particularly for the Ugandans, this information was received way after the claimants had returned to their home motherland, Uganda, where the medical services are clearly not up to standards and therefore negatively affected the results, in bracket points awarded, upon which compensation was paid. As a result, the claimants in question, Ugandans, were awarded 0 points. And for some, the points were said to be non-applicable. And in effect, they were disregarded from the said compensation. This occurred even after the individuals had received payments for registration, for which next phase was meant to be issuance of point notices based on point dollar value, PDV. Out of curiosity, we reached out to the primary counsel, Heninga Garrison, the appointed attorney for many Ugandan claimants, about the anomalies, who interestingly also claims that he did not submit the medical results, yet they were an essential requirement for one to be considered eligible. But then again, he claimed that he was yet to resubmit them, having gotten permission from the authorities to do so. Something had to perceive and buffering, something had to perceive and buffering, to say the least. What is further disturbing is that after submitting these results and audiograms on the settlement portal, each claimant's profile started to reflect points. But the explicitity was that some claimants got 2 audiograms and others got 1 audiogram, while others got nothing at all, which begs the question of what criteria was being followed. Therefore, there hasn't been any positive feedback to our continued search for answers to the apparent dilemma, until very recently, when the silence was broken by the first payment notice, which was registered in form of registration payment notice of $1,000 to be awarded to those who had at least 1 audiogram, whereas those with 0 audiogram got nothing to their names. However, after a number of tracked engagements through emails, this was further exacerbated by the fact that the means of sending the said money as claimed by the Primary Council and Settlement Administrator Brown Greer, was becoming a problem, claiming that because Uganda is a far-away country, they were finding challenges sending the money. After so many complaints via emails from Ugandan claimants to the Primary Council, the administrator of the settlement portal and the judge, M. Cassie Rogers, they finally requested for a swift codes from banks and started sending the first payment of registration payment, as stated herein above. The recourse we have taken is to continually send emails to the concerned parties to avail up until we replied and told that our medicals and audiograms did not warrant us eligibility for compensation without necessarily explaining the criteria used to arrive at such a grave and horrendous decision. But that we can resend emails seeking reconsideration. Our concern, we all participated and sacrificed our lives in the said war zones of Iraq and Afghanistan, used same gadgets, earplugs, as the same US citizens did, and sustained same injuries regardless of nationality. The settlement reached was all inclusive regardless nationality. We submitted our documents and were used to contribute the settlement that was reached. Our rather large numbers was used to make the 98% of claimants in order for the release of 6.1 billion compensation of eligible claimants. We were not duly notified of the need for audiograms points amounting to eligibility. We were never informed that the compensation was exclusive to only US citizens. As you can see, some of these proofs, they clearly indicate that this was a global settlement. So we wonder why they had to include this. The objective of this petition, therefore, is to seek the Uganda Law Society's intervention in providing legal representation and guidance through the processes required to seek rightful compensation and justice by way of, among other things, apply for reconsideration. Additionally, we urge the society to aid, investigate the conduct of the legal representation that occurred during the settlement, facilitate outreach programs to educate affected individuals about their rights, and collaborate with relevant health and legal organizations to support the victims in recovering their rights. Request for action. We kindly request that the Uganda Law Society initiate a task force to look into the claims related to the combat arms earplugs settlement. 2, provide legal assistance and representation to those affected, particularly in understanding and assessing their rights to compensation. 3, organize informational sessions and workshops aimed at educating Ugandans about similar legal matters in the future. In conclusion, we believe that your intervention is crucial in ensuring that justice is served for both harmed by the combat arms earplugs. We individuals deserve legal support to claim compensation and accountability from the responsible parties. Thank you for your considering this petition We look forward to your prompt response and action.
Ladies and gentlemen, thank you so much. Robert Jurua, I'm part of the Rule of Law Department. Would like to thank you all once again for this moment. Mr. Treasurer, I would like to stand on the protocol that has been observed in your presence here as council member representing the president and all the other council members. We highly welcome you. We are so honored to have you around and the guests that have been identified before. We thank you so much, ladies and gentlemen, and the public at large that is watching us online. We thank you for your time. That was a debrief of a petition that we received from these Iraqi and Afghanistan returnees who, basing on our mandate as the Uganda Law Society, as envisaged in the Uganda Law Society Act, Section 3D, that allows and reads, I say, to protect and assist the public in Uganda in all matters touching, ancillary, and incidental to the law. This in particular is affecting these members who went to the Iraqi and Afghanistan, and they have the grievances whose details have been read out to you. We would like to, if anything, add on what has been said using Mr. Migade Ronald, Doctor, who will briefly add on to what has been read, because these are the two individuals who are representing the team of over 3,000 members, and would briefly just want to request that he adds something basic, and then we can move on to hear from the public in as far as questions are concerned, and also a few other speakers who have almost the same topic to discuss with us. Thank you.
It's a good afternoon. It's a morning to all time zones. Morning, good afternoon, and good evening to all time zones. I'm by name of Migade Ronald, humanitarian within Uganda. We went to Iraq to fight against terror. As a Uganda humanitarian anti-terror specialists within a team, we were hired by the American government, so we were supportive onto the American government. Reaching the base, we were given earplugs which had defect. As time went by, we were deployed. We went for range. As I've been elaborating. These were kind of the formations that we had by the due then. We first had formations like SOS before being employed. So once you have this, you are ready to go for range because you are already disciplined by military, and we are being disciplined by the DEO, Department of Defense of America. So after that, we went for range. This is the range. While having this, while at range, you have to have what we call earplugs. But the earplugs which we were using, they were defect. They had some errors within the manufacturing. They had what we call manufacturing errors, mechanical errors. So all the sound within range, remember there are different kind of rifles and gunmen who are shooting at once. So all that sound is entering within your what? Within your brains, within your ears. That means it is impairing or defecting your what? Your hearing system. Are we together? Gunmen, we use guns like this one. This is 50 caliber. We use guns like this one. While at post, This is a gun which can really fire, and you feel the sound within the medulla oblongata. It really enters. So if you have a defect earplug, definitely all that sound will do what? Will defect your hearing system. This is PKM machine gun. This one, without those earplugs, my dear, you cannot survive. To why he's even having what? The level of defectiveness differs to what? To genetical system, the genetical assembling system. So if my immune system is higher, it is not going to defect me as it is going to defect you. We shall be having what? A tangling skid. As by then, we come up with a resolution. After coming back, we were meant to be taken for rehabilitation. We were meant to be taken for rehabilitation within Germany, Jordan, and Kuwait. But we're rationally segregated. Being rationally segregated, we are sent back, dumped to Uganda. Remember, we have got a lot of complications down the road within her health, our health conditions. We were dumped. We were dumped. We were not fit. We were not felt for. We were dumped. After us being dumped, we began developing health conditions, critical, grievous health conditions, whereby we were underpaid and we couldn't even support our medical bills. The medical bills we could have supported us, they were the substandard medical bills. As I have a video here, As I have a video here, which is going to show you one of our colleagues doing what? Being surplus within that kind of what? That kind of error. As it went on, we were meant to be what? We were meant to be compensated. And this was all of us. Those guys, they didn't make the 99%, whom 3M earplug had to do what? Wanted at large. So the 99%, it was got from the Uganda, because they knew that we Ugandans are many to make that what? That percentage which they want, so that they can be paid. The 3M was only to be paying the administrative what? Administrative expenses only and also. But when they saw that the threshold of 99% was intact, these guys came up with a resolution of paying $6.1 billion to all the eligible claimants. Why were we eligible? Because we went in and used those arms and we went out. We had visas to do what? We had visas within our passports to show that this is the proof of what? Of our entry and exits. So once you are within the army, definitely, within the war zone, definitely you have to use what? A gun. And the gadgets which were provided, they were the what? The earplugs. This came to a controversial. This came to a controversial error whereby these are the people who began twisting us up and down, up and down. Why? They didn't want to set us off. They didn't want to compensate us. They sent to us that we did not have, in the first error, they told us that we had settled off with all what they wanted. That they had all the documents which they wanted from the primary council. The primary council had all what they wanted. And the court concerned, certified that they had all what they wanted. Lastly, it is the same court who is saying that we don't have what? Audiograms. Why are they saying that they don't have audiograms? And in first case, they told us they had all what they wanted on time. Lastly, they told us, it has been a long story. as within a struggle. Last we were told, this mass tort is not meant for foreigners. This mass tort is meant for U.S. citizens only. So if you are not a U.S. citizen, you are not being catered for within the what? Within the settlement program. This is real. This is real. Torturing us psychologically. According to the medics which we have within Uganda, according to the medics which we have within Uganda, according to the medics which we have within Uganda, this is the kind of medics we have within Uganda. I don't think it's viewable enough, but those are the clinics we go to within Uganda. That is what we can afford. But if we had gone within that settlement era, we would have got that settlement for what? For a proper medical condition or proper medics for our lives to be what? To be reset. Because we are suffering. Members, we are really doing what? We are suffering. We have lots of complications within what? Our ears. As you have seen, she's really doing what? She's really suffering. She's really in deep pain. That is my what? My say about the 3M earplug legitimate case. Thank you.
Thank you so much. Thank you so much. Ladies and gentlemen, we thank you for continuing to listen in. Honorable Treasurer, like you have noticed, and in light of the celebration of Labor Day yesterday, the Radical New Bar thought it best to necessarily come and hear the plight and also extend it to the public so that they are aware that the Uganda Law Society is a home for everybody, regardless of your challenge. This is particularly employment law, and we're here to say that the Iraqi and Afghanistan returnees petitioned the Uganda Law Society, and maybe, Honorable Treasurer, for you to know, we have made some strides to coordinate with the Ministry of Foreign Affairs, who in turn are also going to help us coordinate this issue, because the matter arose from the United States of America, like has been said, and we are here to say that we are going to take it on through the guidance of Council and Secretariat of the Uganda Law Society. Thank you so much. Ladies and gentlemen, we are also having another team that has the same plight, and that is particularly the Federation of Returnees and Migrant Workers Uganda, who are going to help us to break down to solubility why returnees should be considered and recognized by the government of Uganda. And to help us do that, we're going to have two able speakers. That is one, Mr. Victor Musinguzi, who is the chairperson of the team, and Mr. Agaba Muzora, who is the one of the executive members to the team. Thereafter, we shall have questions and answers to that particular segment of the discussion, so as to proceed with the next program. Thank you so much. We'd like you to welcome with me Mr. Victor Musinguzi, the chairperson for Federation of Returnees and Migrant Workers, Uganda. Thank you.
The leadership of Uganda Law Society, distinguished guests, fellow comrades, ladies and gentlemen, my name is Victor Musinguzi Bagowabo. I'm the president of Uganda Migrant Workers and Returnees Associations and chairperson Special Returnees Association, Uganda Limited. We, the returnees from Iraq, Afghanistan wars against terrorism, humbly request humbly present our petition to your esteemed office, Honorable President, Uganda Law Society, facilitated by Uganda Law Society. Our experiences in these, our experiences in these conflict zones have been significantly impacted our lives, and we seek support in addressing our challenges. The key issues that we face as former operators on the war against terror in Afghanistan and Somalia, we have the problem of the main issue is our DPP points, as he has explained what transpired in the petition. We call upon your office to investigate and rectify the denial of DPP points to Ugandan migrant beneficiaries, ensuring that justice is served and points are awarded fairly. Another issue is reintegration challenges. We returnees from Iraq and Afghanistan, we face difficulties reintegrating into Ugandan society, including stigma, lack of employment opportunities, and limited access to social services. Then we have psychological trauma. Many of us have experienced trauma requiring specialized support and counseling services. As we all understand, in our letter of authorization, our contract from the United States Department of Defense, we have a benefit of resuscitative care that every after contract that we signed, we are eligible to get resuscitative care. Like you get medical examination, general medical examination before you get deployed on the contract, and you are deemed fit, you are examined fit to be on the contract. As much, the contract recognized that every time we finished our contract, we have to go and get specialized care from specific countries, which are also indicated on our contracts with the Department of Defense, which was not done. It was not done, and he has been showing you the clinics which we are getting our medical care, they are not on the standard. They cannot provide that service. Then economic empowerment. We need assistance in finding sustainable livelihood and economic opportunities in Uganda. Then compensation issues. As I have already said it, on the case, all Ugandans have been denied points, and those points are the ones which will convert into money. So if you are a beneficiary on the case, but you have no points, meaning that you have no compensation. So we need fair points provision. Then we have petition requests. Case review, number 1. We request a thorough review of case number 2883, MDL number, ensuring justice and accountability. That's why we are bringing this case to your attention. Then support services. We seek access to specialized support services, including counseling, vacation training, and economic empowering. Economic empowerment programs. Number 3, reintegration programs. We propose the establishment of a comprehensive reintegration program to facilitate our smooth transition back into the Ugandan society, which we have not got a platform to help our members to be able to reintegrate into society and have better livelihoods. Number two, we seek access to specialized support services. Number three. R&B Vision 2060, we align our petition with the RNB Vision 2060, which emphasizes the importance of rehabilitation, reintegration, and economic empowerment. We believe that our successful reintegration will contribute to the overall development and security of Uganda. In conclusion, we appreciate your consideration of our petition, and we look forward to your support in addressing our challenges. Your leadership and guidance will be instrumental in ensuring our successful reintegration, promoting peace and stability in Uganda. We acknowledge the Uganda Law Society for hosting and facilitating this petition, providing a platform for us to present our concerns and seek address. We thank you so much for God and my country.
All right, thank you so much. We humbly receive that verbal petition. There will be a moment where the Honorable Treasurer will, on behalf of Uganda Law Society, receive those petitions. We are going to very fast move to a presentation by Mr. Agaba Muzora, who is an executive member who will speak of himself shortly, within a very short time, elucidate a little more on what has just been stated by Mr. Victor, so that we can move to the next agenda item. Thank you so much once again.
Thank you so much. My name is Agaba Muzora. I'm the Secretary General for the Uganda Migrant Workers and Returnees Associations. I'm here to give just the general picture and to augment what has been talked by my colleagues. I'm personally also a returnee from Iraq, and I can testify before this house that I have 1 ear which does not work completely. I use only, for the case of phones, I use loud. So these things these gentlemen are talking about are real, and they are massive in numbers. As the Federation, we are taking the associations of all returnees from Iraq and Afghanistan. And so we have a collective view of what actually happened, because we have hundreds and hundreds of victims who come to our office on a daily to be recorded for assistance. And so this is not a problem of only these gentlemen who are here in this room. It is for multitudes of Ugandans who went to Iraq and Afghanistan. To paint the general picture, Ugandans started going to Iraq to support the US in its war against terror since 2005. And to date, it is estimated 250,000 Ugandans, actually 258, the Ministry of Internal Affairs says, have worked in the war zones and come back. Most of the war zones we are talking about a war zone which had many nationals, and also we are using many weapons of different kinds and doing all sorts of work, including escorting people throughout the war zone, because like the whole country was a war zone. So if you are in Iraq, it was a complete war zone. There was no safe zone. It was in Afghanistan, the same. So we had people who were escorting. We had people who were manning the facilities, the towers, the security of the towers. And these people had to undergo a number of trainings and were using different weapons. So as a result, they underwent or they received very many complicated cases. I can tell you the compensation, the plea for compensation is not only a Ugandan thing, it's a Ugandan plea. Nationals from the UK, nationals from Germany, nationals from Romania, these people were compensated a long time ago and in massive amounts of money. So that's why we are saying that for the case of Ugandans, we are being sidelined. And that's why we are requesting the leadership of Uganda Law Society, Honorable Treasurer, to help us in furthering our cause. To the Ugandan community, I can tell you that returnees are very instrumental people. One, if you have gone under a military training, you are a person who is resilient, who is hardworking, who never complains of nothing, and so we are not failures. We are not failures, we are actually a lot of trained people and with a lot of potential. But we have what we call integration challenges. When you leave your country for 3, 4, 5 years, and you come back, believe me, you are starting from zero. You see, even MPs here and ministers who get sacked or who leave at the end of their term, we have been on TV. You hear that they are pleading to the government for medical what? For medical attention. So normally, and those who are working from within and able to invest their money. But what about if you have been away? And most of Uganda, if you know Uganda, we have a high dependency ratio. So people who are working are already supporting those who are staying home, who are not working. So some people, you know, they have been saying that people from Iraq and Afghanistan misused their money, they drank it. No, that's not the case. So when we are talking about assistance for reintegration, we are coming from that background. That while we are outside working, we supported our families in health, in education. Personally, I was paying for 6 of my siblings throughout the 3 years I spent there, up to the level of the university. Once they all finished in their 6, that's when I said I can go home and settle. So this is everybody here. That's what they were doing. Some would send money to our parents, buy me this, they don't buy them. So when you see returnees struggling, it is from that background. We are hardworking people, trained people who deserve a push in our integration mission. So we have security skills, but we have also skills in everything we are doing before. Later on, I can assure the returnees community here, as a federation, we are writing a similar petition, but for a reintegration project to the president, and at an opportune time, we are going to invite you to help us present it. So with those many words, some call them few, I would like to thank the petitioners, because we are petitioning on behalf of all the returnees, and the Uganda Law Society have indicated that you have already accepted to take on this case, and justice will be served. We look forward to justice, and we thank you. Thank you so much.
Thank you very much, Mr. Agaba Muzora from the Federation of Returnees and Migrant Workers, Uganda. Ladies and gentlemen, we are still moving on. We thank you for the time you've given unto us. We are also welcoming questions and answers welcoming questions for these individuals who have come to petition the Uganda Law Society. Therein, we shall also get some clarity. As we are all aware, there are so many questions and very many answers unfound. Mr. Treasurer, maybe for your knowledge and for council and Mr. President and everybody around, I would like to recognize the presence of the Rule of Law University clubs in the house. Please. We have with us the Rule of Law, the Makerere University Rule of Law Club in the house. We have with us the IUIU Kampala Campus Rule of Law Club in the house. We have with us the Cavendish University Rule of Law Club in the house. And finally, we have with us King Caesar Rule of Law Club in the house. Ladies and gentlemen, for you to know, the Rule of Law Clubs are baby of the Rule of Law Department of the Uganda Law Society, within which we intend to create awareness using the students in the universities, secondary schools, and primary schools as what we call foot soldiers to enable our work to get easier. And we have one of the very iconic foot soldiers who is a very big part of our session today, our chief guest, who knows what it means to be a foot soldier. We go out there to educate and sensitize the public using the school, rather the Rule of Law clubs. Mr. Treasurer, for your information, there is a petition, as has been said, that is going to be submitted to the Uganda Law Society officially. I don't know, are there any questions that we have for the members that have just made presentations? Any online questions as well? You can keep them coming. I know it's been a rubber dub style, as we call it, and we would like to at least enable that everybody is aware of what's going on. In the meantime, we'd like to invite the Treasurer to officially receive the petition that has just been brought onto the Uganda Law Society for purposes of further action, as is always the case. Please. Thank you. Enoth and Doctor and the Federation. You have the signed one? I gave you a signed one. Honorable Treasurer, before you is the petition. You can join. That's okay for now. It's okay. Yes. So you can tell them to sit again? Yeah. You please take your seats. Thank you. You speak now or you speak later? I shall call you. Okay. Here you're receiving, then you come, then you come later. Thank you very much once again, ladies and gentlemen, for bearing with us. The Iraqi and Afghanistan returnees, you can be rest assured that Uganda Law Society will do whatever it takes to bang that table. And ensure that you will get reconsideration to the best of our ability with our able leadership of the President, who has given us a blessing to receive the petition as well as do anything else that is required. Thank you very much. Ladies and gentlemen, we're moving to the next agenda item. We are going to tackle an issue headed Equal Pay, the plight of state attorneys inside the Uganda Police. To help us break this down to solubility is an advocate of the High Court and all courts thereunder. He is a founder and managing partner of Law Advocates, a law firm in Kampala, situated in Ntinda, and he is a student of life and war. Ladies and gentlemen, welcome with me Advocate Andrew Obam.
Good morning to you. My name is Obam Andrew, and Obam is spelled as O-B-A-M, not with a U. Obam Andrew is my name. Ordinarily, when people hear the name, they always want to know where I come from, but I come from Lira. I am Lao by tribe. Which makes me a Ugandan. Well, my topic of discussion centers around a topic that's quite sensitive in the context that by the time I was invited, there were a few things ongoing in the background, and that is there was a suit that had been filed against the Attorney General. The microphone is short. Can I? You can give the microphone. Thank you. By the time I was invited, there were a few things ongoing in the background. Specifically, a suit had been filed against the Attorney General by some of our colleagues, the lawyers in the police force. Before I proceed, permit me thank the members of the Uganda Law Society Executive Body, the council members, the administration, for the good job you have done to sustain the movement. By the movement, I refer to the Radical Bar movement. Thank you so much. It has not been easy. From the word go, I was involved. I called up the president, Senior Counsel Isaac Semakade, before he was nominated. I called him up and I assured him, I will endorse you. And when the D-Day came, I stayed with him in the trenches. We progressed until the results were pronounced and we had him as our president. Without any further ado, permit me dive in. A suit was filed against the Attorney General. At the time, it was being, the counsel in personal conduct at the time was Counsel Augustine Edot, who is with KAA, Kampala Associated Advocates, quite a very brilliant lawyer. We were given joint instructions at the time when the application for an interim was not granted in our favor. Let me just give you a brief background, what this entails. There was a presidential directive as early as 2008 through the former IGP, where lawyers in police were okayed to earn the same amount of salary as the other state attorneys. I will not go into the details because I keep emphasizing that because there are more than 2-3 forums where this matter is being managed. It so happened that when the matter was brought to court, we were advised to withdraw
the suit. And this was based on one fact. I wrote a letter personally to the Attorney General to have a meeting with the Attorney General to find a way how we can amicably resolve this matter. Why? Because my school of thought was hinged on the fact that you cannot hold government at ransom. You cannot compel government to pay you a particular salary, even though at the time the President of the Republic of Uganda, in his wisdom, felt that probably from the consolidated funds, the money was enough, the money could take care of the other state attorneys. Our discussions were quite fruitful, and we agreed to withdraw the matter. Incidentally, today some of the members were meant to be here, but I was reliably informed that some are in for training and the others could not get by. But I'll speak plainly. As a man in uniform, you can't make certain decisions or walk over here without the input of your commanding officer. So probably that's why they are not here. So far, it has been promising. Reason being, from the time the president wrote, and this stems from one fact that is probably not known to many, and to some of the law students here, I'll make reference to a Supreme Court decision, which is Parliamentary Commission versus Mwesige Wilson. It is a constitutional appeal number 8 of 2016. The justices of the Supreme Court at the time interpreted further Article 153 of the Constitution, and this confirmed the President of the Republic of Uganda as the substantive, I'll borrow my colleagues, my friends' words. The President of the Republic of Uganda is the substantive finance minister. Whereas we have a finance minister who is known by the name of Honorable Matia Kasaija, it is without a doubt that the Constitution under Article 153 confirms that the President of the Republic of Uganda is in charge of budgetary proportions and expenditure planning, which requires him to present the same before Parliament, and this is done through the finance minister. The fact that the president writes a letter, it is now common knowledge that any presidential directive becomes law, but there is a procedure to that. I'm speaking literally, not legally. It is now common knowledge that a presidential directive becomes law. When the president wrote and instructed that our state attorneys be paid a certain amount of money, it was put in place. And this moved on for about a year. Financial year 2021-2022, that is when our good Attorney General advised contrary or otherwise, that please, the budgetary expenses at the time could not match up to what they ought to have been paid. What did this lead to? Most of our colleagues took out loans. It is undisputed in Uganda today, everyone nearly has a loan. 95% of all of us Ugandans have loans. Our colleagues took out loans based on the salary scale that had been enhanced. But now here government comes in and advises otherwise, that please, your salary scale is going to be reverted back to what you were earning at the time. People took out mortgages. Their properties are on the line. The banks will not wait for you. They will sell your property. People made promises somewhere. Life is hard. Life is not only hard in Uganda as I speak today, it is hard everywhere, but life is hard most especially if you have a loan, you won't sleep. And that is why several pleas have been echoed. We've had members of parliament presenting the same petition, asking through the speaker, the deputy speaker, there was a session through the deputy speaker, questioning the Minister of Finance, what next? What are we going to do to cure what some of our brothers are going through? Not to forget, these are people who hold firearms occasionally. Of course, you must sign for it when you're walking out, but they hold firearms. Technically, it is easier to tempt the devil than the devil to tempt you. The reason why I have insisted that my discussion will narrow down a bit, it is because the Minister of Finance on the floor of Parliament confirmed that through the Minister of Internal Affairs that the matter is being handled. Our plea as of today is to use this platform to call upon government to expedite the due process. It is my humble prayer that Uganda Law Society takes this on to continuously press and press and press as we carry the banner of the Vision 2060. In my closing remarks, allow me to analogize. In the year 1804, at the Cathedral of Notre Dame in France, a man by the name of Napoleon Bonaparte crowned himself the Emperor of the French. It is undisputed that Europe had never seen such unprecedented rise to power, war after war. And in history, there has never been a man who has led and earned many more war victories like Napoleon. However, during his time, between 1804 to 1814, there has never been a man who has faced so much resistance and opposition like the Emperor of France at the time. And this is my kind reminder that when our president coined the idea of the radical new bar, it's upon you, the litigants, and the citizens of this republic that do not stop keeping your mouth. This is the time, this is the era that you start using your pens and papers. Thank you. This is the time and era that you start using your pens and paper to speak the truth. I've been to WhatsApp groups where people are being ejected for speaking the truth. I keep telling my colleagues, as a man, I'm not that very old, but if your father is around 70 and is still chasing around girls at the age of 30, 25, it's time to tell him, Dad, this is wrong. And let it apply to all of us, the lawyers, the returnees. I've had a few clients who returned from Iraq. And of course, I know what is happening. Some of you have received payments that have been swindled by purported fraudsters, and some of these are American citizens, for the record. And I'll say this without fear or favor. We need to stand and re-echo. Let's use this platform. Thank you so much, Arthur Isiko, a very good friend of mine. Thank you so much for the leadership. Benon, thank you so much. Thank you so much to you all.
Another round of applause. Thank you so much, Council Obam Andrew from Lao. We appreciate your enthusiasm. We thank you for the words of wisdom. Ladies and gentlemen, we are moving on well. We are in the same spirit, trying to see how to speak out like it is about the radical new bar. We are radical because we speak the truth, and we speak the truth from the root. And it is the duty of the Uganda Law Society under the radical new bar and the able leadership of President Isaac K. Semakade to enable us to ensure that the rule of law is adhered to as a nation. So we thank you so much for working with us. We thank you for the speakers. We're very happy that you're here with us once again. Ladies and gentlemen, it is around this time that we are also welcoming questions. Feel free to ask the questions. Those online are also allowed to send their questions online. We can always pick them from the chat box, and we shall be able to answer them. And at this time, would like to welcome the Rule of Law University clubs that are going to give us a word of thanks, specifically the president of the Rule of Law Club from IU, who is Ryan. Is Ryan in? You're most welcome. Then after that, we shall have Elena, who is the president of the Rule of Law Club of Cavendish University. Please.
A very good afternoon to each one of us. Yeah, in a very special way, protocol observed. I thank you all for coming today. In a very special way again, I welcome the returnees and thank you for the patriotic heart you showed to your country by taking on the call when it was due and when it was necessary. Besides, I'm very saddened that they had to go through such a thing. They fought not only for themselves, but for the rest of the people in Afghanistan. But I'm very saddened that up to now, you're still suffering. You still have the pain that you should not even be having. However, I call upon other stakeholders to come and support, to come and do the needful, to come and speak up. Each one of us can do something towards this call, and that is why we are here. We have not come here for formalities. We've not come here to take photos. We've not come here to have a tea party, but we've come here to claim for what is supposed to be theirs because they actually did the work. And we, as the students body, Rule of Law Clubs, we want to thank the ULS for giving us an opportunity to come and be part of this cause. And we promise the ULS and the Treasury that we shall work once we are called upon towards this petition to see that the returnees receive justice. And I would like my colleagues to introduce themselves. I didn't introduce myself at first. I'm Helen Nyakaisiki, a student from Cavendish University. I'm in year 3, semester 2, and the President Rule of Law Cavendish. Thank you.
Good afternoon to you all. My name is, I beg to stand on the protocol that has already been observed. My name is Wavamuno Ryan. I'm a student of IU Kampala campus and the president of the Rule of Law Club there. A good afternoon to you all. First and foremost, would like to thank the Uganda Law Society for such an opportunity it has granted to us young leaders to come and sit down here and benchmark on some of these things. We really don't take it for granted. We are students as of now, but that doesn't presuppose that there's nothing we aren't in position to do. Our voices, on top of the voices of the stakeholders, can be able to make a difference in this country. I believe and I know that when we speak on top of the voices of the stakeholders and the people that are up there that are able to do and help out these returnees from Afghanistan and Iraq, we believe and know that a change that we advocate for and we anticipate for shall be able to be brought to manifest. And as students, thank you. As students, ours is to really give in our best whenever we are called upon. We are willing to stand, we are willing to help in petitions when we are called upon to do research. We are so zealous to do so much within the little time that we may be in leadership, even outside. We really sympathize with you all that have been disgruntled by the system, and we pray and believe that the Almighty God sees us to the day of victory that we anticipate for. And to the Uganda Law Society, to the Treasury, and the President, Senior Counsel Isaac Semakade, we are so much delighted for such an opportunity granted to us, young leaders, to come and take part in such. And we're looking forward to the very best. The climax of it all is success. I wish you all the best.
A very good afternoon, everyone. Protocol observed. My name is Arnito Ambrose, a student at King Caesar University, doing Bachelor of Laws in my second year, second semester, and I happen to be the President Emeritus Rule of Law Club. I'm delighted to be with you here, most especially the so-called heroes of Uganda. The returnees from Afghanistan, I take you to be the heroes of this country. But when you compare Uganda with other countries, as you have said, that other countries, the heroes have been compensated, but for it is not. It is on a bad note that we Ugandans, most especially the top leadership, we take our heroes like as if we don't know what they do. You are the people who fought for this country, and I think the treasury of the Uganda Law Society, as he has said, is going to take the petition, and on behalf of the Rule of Law Clubs, for us, we are there. Whenever we are called upon, we are going to participate with you, and for us all, I call upon that we fight for justice and fairness in the country, as well as the Uganda Law Society. Thank you very much.
Protocol observed. My name is Jenny Rankunda, King Caesar University, a second-year law student. I'm very delighted to be here, and all I can say is applause to the Uganda Law Society Executive and the Afghanistan returnees for giving us a reason to indulge ourselves into critical thinking. It gives us a basement and a reason to think beyond what we are capable of thinking. Like, we open our minds to thinking more of initiatives and open to the role. That's all I can say. Thank you so much.
Hello, good afternoon. I am Okwelo Christopher, a student of Cavendish University, Uganda. I am really delighted for being here for the invitation by the Uganda Law Society. I would not love to say much because my colleagues have already mentioned a lot. And for the sake of time, I wish you a happy afternoon.
I stand on the protocol observed. My name is Katsime Erin Mwesgwa, a student of Cavendish University, Uganda. I'm pursuing law. I'm in my second year, second semester. I'm very privileged to be here, and justice shall always prevail for God and my country.
Good afternoon, everyone. Protocol observed. My name is Namayanja Gloria, bringing the warmest greetings from the Islamic University in Uganda. And we say Assalamu alaikum wa rahmatullahi wa barakatuh. I'm the Senior Presidential Advisor on the Rule of Law Club, Islamic University in Uganda. I'm in my second year pursuing my bachelor's degree in law. And to the Uganda Law Society, please receive our most heartfelt gratitude for inviting us to be part of you today. And basically, my word would be that, just like my colleagues have said, justice will always be served, and we are here to uphold that. And I'm assuring you that we, as the young generation that side at university level, we are doing something. And when that time comes when we are able to put it on table, inshallah, we are going to table something. Thank you for listening.
All right, thank you so much. We have a whole presidential advisor in the house. Ladies and gentlemen, this is no joke. The Radical New Bar receives all kinds of people. A very big round of applause for the students. We are very honored to have you here. We have been working together differently as we keep approaching the schools as they are set up in different locations. This is just a little bit and a snippet of who they are. We want to thank you for honoring the invitation. We also pray that the Lord blesses you as you continue to partake of what you're doing without fear or favor. Would like to invite the Honorable Treasurer to take a picture moment with them so that they can also go back and show off with their colleagues that they are from this side. Honorable Treasurer, please, we indulge you, if it's okay. Thank you. Stay here. All right, all accommodating presidential advisor, the ULS governor. We are honored. The governor is the treasurer, who we respect here, and every word he says is a law. We thank you so much. Ladies and gentlemen, our next agenda item is the last of its kind, and we are going to go to a very special moment, the highlight of the day, that we are going to try as much as possible to do with all the colors that we can. And the next agenda item is something that you're all going to be awed about. It's going to be memorable. We are going to take a moment to honor one of the most vibrant rule of law champions. And yes, we within the House have a very astute individual, a lawyer by profession, who was born in Lugazi. He attended school in Kokonjeru Muslim Primary School. He then attended Kawempe Muslim Secondary School. He pursued a bachelor's degree of law in Makerere University and was a member of Nkoba Zambogo Students Organization. He has been involved in very high-profile cases, including, among others, the Robert Chagulanyi Sentamu Bobi Wine's academic credentials during the 2021 presidential elections, the challenge of the constitutional amendment allowing President Museveni to extend his term of office beyond the age limit, the age limit that is, he contested that as well, and he has been described as a maverick lawyer who fears no one and is known for taking high-profile cases. Some people have questioned his motives, and some labeling him as someone who is not okay and fearful. Despite all that, he remains determined determined to challenge the status quo and believes that the rule of law is the way to go. Ladies and gentlemen, welcome with me Mabirizi, who... Thank you so much. We are going to invite one of our foot soldiers, Council Yasin, who is a chief foot soldier of the Radical New Bar, who has stood with the cause. He is a part of the Vision 2060. He has ably represented the Radical New Bar, both home and away, and he is going to take us through a citation that is going to honorably welcome our colleague, Mr. Mabirizi, to the podium, and therefore other items will follow. Ladies and gentlemen, welcome with me, Yasin Munagomba.
I stand on the protocol observed. Dear colleagues, once again, my name is Sentumbo Yasin Munagomba, head ideology of the Radical New Bar. This is the citation for the Rule of Law Champion Award presented to Mare H. Mabirizi Kiwanuka Kasim, Kampala, Uganda, 2nd May 2025. For 10 tumultuous years, Mare Mabirizi has been a thorn in the side of tyranny, a relentless crusader against the corrupt and complacent who seek to trample the foundation of justice. Is not an advocate adorned with robes of the bar, nor a member of its privileged ranks, yet his gallantry surpasses that of many who claim such titles. His incomparable journey of legal and civic activism is a testament to raw, unfiltered courage forged in the fires of struggle and tempered by trauma of a system hell-bent on silencing him. Mabirizi has faced trials that would shatter the faint-hearted. He has endured the sting of persecution, the weight of threats, the cold shadows of an 18-month prison sentence dangled by a rogue judiciary, and the bitter taste of loss and betrayal. He has withered relentless calumny, ostracization, and economic strangulation designed to bankrupt his spirit and stymie his pursuit of justice. Yet when the easy path of exile beckoned, he spat in its face, choosing instead to stand defiant on Ugandan soil. His refusal to bow is not just a personal triumph, it is a radical rejection of oppression, a middle finger to those who mistake power for legitimacy. Through tears shed in moments of despair and fears confronted in the dead of night, Mabirizi has risen against and again. His victories are not mere legal wins, they are devastating strikes against corruption, uncompromising His victories are not mere legal wins, they are devastating strikes against corruption, unconstitutional rot, and the suffocation of the voiceless. He has dragged the powerful into light, exposing their sins, and in doing so, he has planted seeds of hope in a nation yearning for a rule of law that serves all, not just a few. This is no solitary struggle. It is the beating heart of the Radical New Bar. It's the beating heart of the Radical New Bar's Vision 2060. Like Mabirizi, we envision a Uganda where justice is not a luxury for the elite, but a birthright for every citizen, where the law is a sword wielded by the people, not a shackle forged by the powerful. His pain, his resolve, his unapologetic audacity, these are fuel that propel us towards 2060. a future where the rule of law is radical, uncompromising, and fiercely alive. Today, we gather to honor a titan, a citizen, a lawyer, and an unyielding force who has waged a fearless, decade-long war for the rule of law in Uganda and the East African community. It is my privilege as president of the Uganda Law Society and the torchbearer of the Radical New Bar to present the Rule of Law Champion Award to Comrade Male H. Mabirizi K. Kiwanuka. In bestowing this award on the most indefatigable litigant and civically active Ugandan of the decade, we sound a war cry. We pledge to march beside Mabirizi, to amplify his voice and to ensure that his sacrifices, his tears, his trials, his triumphs echo through the annals of our nation's history. This is not a moment of quiet celebrations. It is a call to arms of every Ugandan who dares to dream of just tomorrow. Treat Uganda Law Society henceforth as your home. Male Mabirizi Kiwanuka Kasim, you are a rule of law champion, not because you sought glory, but because you refused to kneel. In you, we see the radical spirit of a new Uganda. Let this award be a beacon, a promise, and a provocation. The fight is far from over, and we will not rest until justice reigns supreme. Isaac Kimaze Semakade, President, Uganda Law Society. Ladies and gentlemen, esteemed colleagues and fellow warriors for justice, this is the President's message.
Thank you so much, Head of Ideology, Yasin. Let's give him another round of applause. Yes, we are going to take the opportunity to welcome the Honorable Treasurer to offer this award to our Rule of Law Champion and our chief guest today. Honorable Treasurer, you're kindly welcome to offer this award. We shall also kindly raise to our feet in honor of our Rule of Law Champion. Thank you so much.
It's my singular honor to award
receive you, feel happy in this place. We shall never and never forget you. We are happy to receive you, welcome. We are happy to receive you, welcome. We are happy to receive you. We are happy to receive you. We are happy to receive you, welcome.
Zaffe tuba nazo. Yono. bulijjo nga tumunoonya tukufunye. We have found you here. So ladies and gentlemen, my name is Mala Black American, other boy from California. Yeah, ladies and gentlemen, my name is Mala Black American, other boy from California. And of course, it's very happy, like, I'm trying to say that Malay Mabirizi is trying to back and I was recognize the rule of law. What did you know? Ladies and gentlemen, my name is Mala Black American, other boy from California. And I record Mary has to better. We're comedians, but we love law. We love the rule of law. We're radicals also. Yeah. Sir, it's very beautiful. It's very beautiful today that we having a friend over here, Malay Mabirizi. A Burkish worker, I came around 10 years of breaking us, working and trying to say the rule of law in Uganda. A life is supposed to work for that reason, so working for that. Oh no! Do you know why I love? Do you know why I love this guy? No. There's one thing, ladies and gentlemen. This guy is one of the most committed lawyers we have in Uganda. Guys,
He's our friend. He's your friend, and he's our friend.
He's our friend.
Fate friend waffe tumwagala
We know him better.
Tumumanyi no basinga.
From there,
yes.
You find this guy walking on the street with his bag behind him, with a bottle of water. You ask him, Mabirizi, where are you going?
Where are you going, Mabirizi?
I'm going to court.
Mabirizi, why are you using a border?
It is okay, rule of law.
Mabirizi, why a bag and a bottle?
Because I am going to court. What are you going to do?
What are you going to do?
I'm going to report God. Ask why?
Why?
Because why did he tell us that he's coming back and he's not coming back? This guy. Ladies and gentlemen, a hand of applause.
Yes.
For Mr. Malay Mabirizi. We love you so much, sir. We love you so much.
We love you so much. To primary school.
Back on track. Isaac yalitunze natugamba tujje tukunyumizeeko olwaleero banange. It's very beautiful. We comedians, when you shake lawyers in hands and nine. Gwe yitamu
nzija mbadde njagala osooka omalirizeeyo
ajja bakiikirira nga abakutte
asa naawe tukulina
kati naffe tulina we twekutte era kale
sir, thank you so much for your time. Governor. Thank you so much. We are comedians. We are called Mary Hearts Tumbetu. We always at Comedy Store. We love this. This is our brother. And Isaac is also our brother. Thank you so much, ladies and gentlemen.
Thank you so much, Mary Hearts. I think straight to the point. On behalf of the Governing Council of Uganda Law Society, we shall be presenting this award to Malay H. Mabirizi K. Chiwanuka on this second day of May 2025, in honor of the tumultuous decade spent fighting gallantly for the rule of law in Uganda and the East African community.
Thank you so much.
Okay.
Please take your seats, please. Mr. Malay is going to is going to give us an acceptance speech. That was an icing on the cake. We thought we deserved some humor, and you can trust the Radical New Bar to do everything as you will. So we thank you so much for for being with us. Thank you. Ladies and gentlemen, Mr. Malay Mabirizi.
Ladies and gentlemen, introduction has been made to me, except that first of all, before I go into the introductions and commentary, I need to thank Uganda Society, of course, the current government under Isaac Semakade, whom we vehemently campaigned for this prestigious award. It is so heavy, I don't know why it's made of what. So I'm actually thankful. I'm very thankful for this award. Where does that go? I'm thankful for this award because it is very important that we are awarded when we are still alive. I've been telling Munagomba, he was telling me that you brought me to this, I never wanted these public things. I told him, yes, I'm soon going to leave you here because when they start giving me awards, time for dying has come. It means you have done, in Uganda we say, Boba kwebaza, ngomanya lulimi lukozechi, luweze. So, olulimi lugenda luwera. So, I'm very grateful. The rest shall be in my speech. Not actually a speech, it's a paper. When I was told that today I'm going to be honored, I organized a paper which I'm going to deliver. Because since it is actually directly linked to what is here, we shall go straight. I shared it. At least I shared the cover page. Maybe these Rule of Law Club students. And I'm happy to have you here because that amuses us. That gives us hope that tomorrow there are some people to come. There are some people who are going to take on this. Because rule of law is something, enforcing rule of law in Uganda and many other developing countries is something very hard to cope up with. First of all, there is no money. As young lawyers, you are going to be told that it's no more. You can just come and fight for rule of law. Some of you think we are rich, but in reality, you find that we are not rich. And do you know why we encourage you? So that you like it, so that when you are trapped up somewhere, when you are here and there is no money, you shall always remember that Mabirizi was doing it. Why should I run away? Personally, I was trapped by people like Rukwago. They could encourage us somehow. You see them working, and you think maybe things are working out. It's after when you come, you discover that actually there is no money, but you are trapped in the middle. You have nowhere to go. So you continue work. So I welcome you here. This is before I go to my paper. And I think I need to comment about, to thank the staff here, Uganda Society, for being flexible. Because I think most of you are recruited under the governments which are not radical. The governments which were moving so slowly. Those normal routines which are not moving. But it's good that you are becoming very adaptive to the speed at which you want the bar and actually the law to move. You said your name? Jurua, you said that Section 3D allows ULS. That word is so simplistic. It is a weak word. That section mandates you. Uganda State has a mandate to help people in rule of law matters. So it's not just allowing you. You are not a pro bono thing that you can choose who to help and not to help. The Act says you must do this. You are not a normal civic society organization incorporated by Agatha Twaire and Toko. No. You are a body, first of all, it's a branch of parliament, but also recognized under the constitution to do rule of law work. That's why when you got the constitution, Composition of Judicial Service Commission, we say members of the judicial service, yet you are not set up by the Constitution. So it's not about allowing, it's about ensuring that you do the work. Iraqi returnees, before I go to my paper, I understand your predicament, but I also blame you for not being civically active enough all this long. See, the Constitution of Uganda, when you go to section Article 17, objectives, they tell citizens to be proactive. Even in Article 3, you must be proactive. But better late than never, you are here. About your social standing, the psychological, also yourselves, don't belittle yourself in the public. Move out. You be active. I don't think someone will victimize you if you are there, you are the Secretary of the Defense, you are the Secretary of the local council. We'll even remember that you are returning from Iraq. That would be secondary. You get the point? So socially, you be with us. Participate with us. If you see us fighting for rule, join us. You get the point? Otherwise, if you don't, some of these things would have been sorted by yourselves had you been proactive. Had you been participating in each and everything that comes up. For example, I've never talked to any of you, but you are crying for many years, people are not paying us. Msema does just come to power. So be proactive, participate in your own society. You see, when you become not participative, I've been even telling civil servants, when they retire, they die early. Do you know why? They keep themselves in the house. You see, I'm a pensioner. He wakes up at 10. I'm a pensioner. At the end of the day, the body weakens. So be proactive. Then we shall also help you. I think, Mr. Obama, I think your predicament reaches up with my paper, which is titled Lawyers versus Lawyers. So you are talking about a situation where a lawyer in Chiwanuka say that his fellow lawyers in police should not get a pay. That the lawyer there should only get a pay as Ganwell does. Someone is a lawyer because he's in the police, he said no. What should they give you extra money? So that's a predicament which I'm going to discuss. Otherwise, thank you so much. Ladies and gentlemen, I now move on to present this paper in appreciation of the award and, of course, to contribute to our posterity and further rule of law. This paper I prepared is titled Lawyers versus Lawyers. 2015-2025, a decade of Uganda lawyers trapped by federal lawyers. I'm presenting it this day upon my being honored by the Uganda Law Society. The soft copy is available. It will be circulated. Even Adam has it. So, fellow citizens, East Africans, and legal professionals globally, on 22nd April, why are we saying 10 years? It's because on 22nd April 2015, 10 years back, I think we have bypassed it, but today is 2nd May, by about 10 days. So 10 years back, I filed Uganda High Court Civil Division, Miscellaneous Cause number 64 of 2015. That was Mabirizi versus Kabaka of Uganda and Katikiro Charles Peter Maiga and two others. Now, the second respondent, Charles Peter Maiga, is a lawyer. Now, this case was of no direct personal benefit to me. Of course, not like those other cases, you know, in commercial court. I think those in commercial practice have read my cases in commercial court, MK financials, MK creditors, the interest rate, what and what. No. Not even the other one of execution division, where Unyidolo awarded me some. Unyidolo gave me damages of 1,000 in 2014. He said, this was for my rent, this was for rent was illegal, but he said he's awarding me 1,000. I even refused to collect it. Anyway, he gave me costs. Now, this time, in this case against Kabaka, prayer number 1 was an order, that issue, declaring the judgment of the first respondents clan tribunal, Koti Yachisekwa, dated 26 September 2001, as the guiding and binding document on election appointment of the Kobe clan of Uganda, and that persons elected and appointed in line with the judgment are the true traditional heads of Kobe clan. So surely, this was my first case in court for the benefit of other persons and interests, albeit this time it was my own clan, whose leadership was started in second year of my law school. So this journey started at a clan level. At a clan level fighting who is a leader, then we come to court. So what was the outcome? It delayed in court. By the time it was time in 2019, the Quack leaders had been thrown out by the then, but by then, of course, the Kabaka threw them away and ours took over. Of course, I succeeded, but second Amosa refused to give me costs and damages. But we moved on. So that's why we are talking about the 10 years now. Now, our 2015 challenge against unlawful back course pre-entry exams was very novel. Bring out the lawyers versus lawyers. On 8th December 2015, High Court Miscellaneous Cause number 188 of 2015, this was Malay Hassan, First Attorney General, was filed with prayer number 1 that an order that issue declaring the advocate's professional requirement for admission to the postgraduate back course amendment notice 2010, legal notice number 5 of 2010, null and void, for being made at traverse the powers of the Education and Training Committee, Education and Training by Section 6C, 1C of the Advocates Act as amended, contrary to University and Other Tertiary Institutions Act 2011 as amended, 2001, the Law Development Center Act, and a threat and an infringement to the applicant's fundamental right to education and right to practice his profession. That was my prayer in that application. But here, the lawyers then, at Law Council, under the hand of Professor Sempeba Frederick, had connived to block their fellow lawyers from practicing law by setting up purported exams without any syllabus or study model. They tell you are going to sit exams, they never told you anything, but they tell you have failed. So this was a lawyer signing such. They thought the expansive number of lawyers in practice would threaten their grip on the market. Now, what happened? Another lawyer called Judge Nyanzi Yasin, betrayed fellow lawyers by not nullifying the unlawful back course pre-entry exams. Now, to their side, the Professor Sempe there was another lawyer sitting as a judge, Nyanzi Yasin, who at page 6 of this ruling is not Yuli, but I have it, overruled my objection to late affidavit in reply. He went ahead to hold at page 10 that since this application ought to have been brought under judicial review, it is dismissed for being time-barred and for commencing under a wrong law. Now, this judge clothed his weakling reasoning, designed to further curb his fellow lawyers' right to practice the profession that, I quote him, my view is that it would be a bad precedent for this court to allow claims of statutory breaches that would by reason of procedure would have been prosecuted by judicial review causes to be brought as causes of enforcement of rights. The applicant ought to have known that he was barred by time and hence circumvented this by sugarcoating the application to appear like it's brought under Article 50. He clearly read into my application what was not written there. What did he mean by sugarcoating? Yet, the art of practice tells us to invent methods of seeking remedies, notwithstanding the time limits. If I avoid a time-bound procedure and adopt another one, why was he concerned? This judge was very strict on what he thought would have been the right procedure to challenge illegalities in blocking lawyers from practicing, as opposed to the professor Sempe gliding illegalities, including turning his person into law counsel. This was a contradiction in his own ruling, where he had earlier, in allowing the tormentors to file a reply out of time, he held at paragraph 7 that even if the affidavit was filed out of time, Article 126(2) of the Constitution allows this court to administer justice without undue regard to technicalities. So to this lawyer judge, Nyanzi, when it came to opposing the lawyer's right to practice, time was a technicality. But when it came to interrogation of the legality of pre-entry exams for already graduated lawyers, procedure was paramount. He even found us to be out of time under judicial review rules, under which we did not proceed. Now, this is the hypocrisy of lawyers when it comes to protection of fellow lawyers' rights, the Obama scenario. I have no grudge against retired Judge Nyanzi Yasin, but tell him he was very hypocritical and cowardly at a time when his profession needed him most to help empower the young lawyers benefit from their degrees for those who want to practice. Now, it is non-lawyers who rescued lawyers from unlawful back-course pre-entry exams. In the end, it is non-lawyers who were engaged to rescue lawyers from the traps set by their fellow lawyers. It was Parliament which blocked the budget of Law Council that finally ended Professor Sempeba's ruining of lawyers' careers under the back pre-entry exams. This same professor decampaigned Isaac Semakade when he stood to be president of the Royal Society, and up to now makes comments which do not add up. We have since come to realize that Professor Sempebwa belongs to a club of lawyers who don't want to see any lawyer thriving except his real descendants, allies, and partners. This is dangerous, and it is catching up with him. Now, the radical surgery of the legal profession by President Isaac Semakade is very important, and we must bear with the pain. If it takes fellow lawyers to disembark traps set by senior lawyers against junior lawyers, it is clear that there was something fundamentally wrong with the legal profession, hence the need for the radical surgery currently being undertaken by President Isaac Semakade. Don't expect these obstacles to normal flow of do not expect these obstacles to be normal flow of professional blood. No, don't expect these obstacles to normal flow of professional blood will not resist. They will resist, but we must remain firm to conclude our operation. Otherwise, our own existence is at stake. Historically, allow me to refer you to the words of Field Marshal Idi Amin Dada, who was reported by Voice of Uganda newspaper of 7th November 1972 upon expulsion of Asians. He said that, I quote him, "We have now won the battle and must embark upon the next battle, which will be for all the people of Uganda to overcome any temporary inconvenience as an aftermath of the battle we have won today, despite threats and blackmail. So that when the failed nations look back in history, decades or hundreds of years, if they do not remember us for any other thing, they will at least remember us for putting the economy back into Ugandanese hands." So, the Amin's message is coming almost many years is dead. The inconvenience of 1970s were scarcity of goods, collapse of economy, hatred by superpowers, among others. In our perspective, we must persevere prison, exile, blackmail, financial starvation, through which Wachuanuka abusing from the General's office to refuse to pay what is due, like he did to Center for Legal Aid headed by Isaac Semakade, whose over 750 million shillings, almost $1 billion, payment was blocked in 2021 after the same was advertised, among others. But the message from President Idi Amin is that they will come to pass and history will be on our side. So Sekana Musa was a low-foot soldier in court corridors, struggling to pay rent. The lawyers versus the lawyers. During 2016 parliamentary election petitions, I actively participated both at High Court and Court of Appeal. And this is where I interacted with President Isaac Semakade more, but that is for another day. Relevant to today is that I interacted with lawyer Sekana Musa many times. He closely worked with another lawyer, Musa Kabega. At one time, Sekana rushed out of court back to office, explaining that he was going to sign a check for rent because his office would be locked by landlord. Advocate Joseph Chaze was present as Sekana said this. Sekana may some lying. But to some of us who knew this legal foot soldier, who juggled all legal trades to survive, including writing pamphlets, part-time teaching at universities and law development center, we are very dismayed by how dangerous Sekana later became against fellow lawyers he used to survive with. Sekana is living testimony of our title, Lawyers versus Lawyers. Sekana Musa's first accomplishment as a judge was to dig a big trench between his chambers and lawyers. After a lot of lobbying from traditional and religious leaders, senior lawyers, politicians, so that Sekana could escape harsh legal practice, he became a judge in 2018. I think this time we had actually argued a legitimate case. And his first accomplishment was to dig a big trench between his chambers and lawyers, calling them all manner of names, including stupid, rubbish. Sekana hates how other lawyers survive, and he thinks all lawyers must do his way. He hates lawyer politicians, he hates human rights activists, hates commercial lawyers. All his hate is against lawyers. Take an example of his passage. In his 21st January 2021 ruling, in High Court Civil Division, consolidated miscellaneous causes number 237 and 431 of 2019. You shall look out for it. It's on Yuli, I think. This is Mabirizi, Elias Lukwaga and others, versus Byabakama Simon Mugenyi, Electoral Commission and others. He delivered this when he was resident judge in Mbarara. He said, lawyers have resorted to using underhand methods to get the judge out of the case, are trying to politic in court and invite the press in order to make some political capital out of a case as we are nearing national elections. I shall proceed to determine this matter even if I was transferred to High Court of Uganda at Mbarara. So if it's not all about lawyers versus lawyers, why should a lawyer be bothered that his fellow lawyer is gaining political capital from a case? Important to note is that our opposite counsel were led by Chirewa Chiwanuka, now tormenting Obama and others, who behaved in court as a person who vehemently opposed our recusal application against Sekana. He badly wanted Sekana in the case. So you can see how far we have both come from. Now, the imprisonment rulings against me and Semakade, of course by Sekana, are a distortion of jurisprudence based on envy and intrigue. That you find a lawyer uses envy and intrigue to distort the jurisprudence. It is now clear to everyone that Sekana decisions against me and Semakade Isaac are basically about a lawyer hating a fellow lawyer, hating fellow lawyers, and abusing office to satisfy his ego. Good enough, he left High Court. Now, for your information, Sekana Musa, even if you seem to be promoted, to us you are demoted because you can no longer sit alone, send us in prison. Shame on you. This is a lawyer who has used his intrigue to destroy the jurisprudence. Take a look at decisions which sent me to 18-month imprisonment and that sent President Isaac Semakade 2 years imprisonment. Let us start with High Court Civil Division Miscellaneous Application number 843. Of course, for students, I want you to look up these cases and read them. And you are at universities, you're not at high school. At high school, you are supposed to write. University, you think and analyze. Now, this application 843-2021, Attorney General versus Mabirizi, ruling number 2. He has 2 rulings. Without prejudice, lack of evidence that I own and manage ex-handle called Mabirizi HKK, Sekana says he was intrigued by statements posted there. In his ruling, he says that he was intrigued by the following words. Sekana is a disgrace. He's not fit to even sit in a small family tribunal. Was never qualified for Uganda Law Society award. He's extremely unethical and incompetent, even to win a magistrate grade 2 award. Sekana needs to be taken for mental checkup. Sekana also lacks courage to do just without fear and favor. He's biased, suffers from the vice of self-interest, is tardy, indolent, and incompetent. Fell in the romance of aggrandizement and populism. He is a danger to the state and society. Sekana's decision is null and void. Then was also intrigued by a post by Isaac Semakade that this judge has either a small brain or a small penis. But neither of his lordship's inferiorities would be cured by the Uganda shilling 300 million shillings fine imposed on a law champion. Judiciary should do more to restrain its young tax from embarrassing comrade. No, embarrassing. Then he said that I said, Comrade Isaac Semakade, you are good to go on with ascertaining the actual size of the judge's animal, since upon sealing and signing the notice of appeal by court, serving it upon Chirewa Chiwanuka, Court of Appeal will determine the size of his brain. Many words Sekana says annoyed him. Now, when a lawyer gets annoyed, this is what he said. He said, however stupid or useless an order may appear, it must be obeyed. This is a count of laws, not of men. The respondent, that was myself, should be arrested and imprisoned for a period of 18 months. So a lawyer got annoyed, and to satisfy his getting annoyed, is 18-month imprisonment. So this is the real lawyers versus lawyers. This lawyer told us, that is Sekana Musa, that he made stupid orders, and he knows. But he said you must also stupidly comply with them. When you rejected prison, this is abuse. Let's move on to the second decision of this man. High Court Civil Division Minister's application number 49, 2025. This is within the space of 10 years. Now, 2025 comes back. The case is Mugisha versus Semakade. It was alleged that it was posted on X-hand of Isaac Semakade that, let me quote what Sekana. Again, he says he got very much annoyed. So when a lawyer gets annoyed, and when he gets annoyed, you see how he reacts. If he was not a lawyer, I think he would be cutting off people's heads. Radical new bar warning. We are investigating serious allegations of people of a possible unwhole alliance involving Judge Musa Sekana, Anojero Chiwachi Uganda Society, Masqueraders, and Judicial Service Commission, Lucy Sebatindira, and Nora Matovu Winnie. This alliance allegedly aims to undermine the integrity of the December 17th Judicial Service Commission ULS nominee elections by manipulating the injunction case. Judge Sekana, beware, the bar is watching. We will not hesitate to take radical action to protect our independence and integrity. Enough is enough. Then he said that Sekana launched a hashtag dubbed Sekana must go. Sekana's predisposition to serve the interests of any corrupt establishment is well documented. We will not stand idly by while regressive elements from the judiciary attempt to stifle our legitimate activities. The Radical New Bar is mobilizing to document and expose additional instances of judicial misconduct involving Judge Musa Sekana, a smaller penis, whose sexual harassment had been confirmed. Red highlighted the word boycott in Justice Sekana. In this ruling, Sekana says he was very much annoyed. Of course, he sits as a judge in his own cases. When he gets annoyed, he picks a pen and the paper writes a judgment. This is what he wrote. He said, the respondent statements on his Twitter handle, Isaac Semakade, and the letters as president of Radical New Bar, as set out here in the affidavit in support, were contemptuous and intended to scandalize the court or to show that the respondent, as president of Radical Society, is above the law and untouchable, or he is banging the table of the judiciary and is at the liberty to throw any obscenities against judicial officers with impunity. The judiciary and the court specifically must fight for its space and protect its authority from attacks by any such litigant or person who scandalizes it, like the respondent, and his arc of followers or alleged foot soldiers. I said he was also a foot soldier, who have specialized at attacking judicial officers. The repeated nature of the attacks by persons knowledgeable in legal matters and duly elected representatives of Radical Society invites this court to send a strong warning and caution against future contemners, foot soldiers, the chief soldier, foot soldier, and respondents in the main cause to desist from such conduct in future. The respondent should be arrested and imprisoned for a period of 2 years. He gets annoyed. 2021 was 18 months, now 2 years. It is therefore clear that this lawyer, who was once a foot soldier, running to save his office from being closed for lack of rent, finds happiness in having his fellow professionals in prison. Now, that's the title, Lawyers versus Lawyers. Now, Owinyidoro is another lawyer versing fellow lawyers. As I began this paper, I talked about another lawyer called Owinyidoro. Now, this lawyer was a member of parliament. First of all, he was a member of Constituent Assembly, which made the constitution, and later parliament, becoming minister before he was docked in 2006, replaced by Professor Genga Latigo. He joined the bench in 2008 at High Court, after 2 years of returning to his post office-based law firm. He had a law firm there at post office called Ujiro and Company Advocates. I last saw it when his wife was sitting there. Now the wife is also judge. Is it now justice of appeal? I don't know if it has closed. So anybody will tell me. But I worked with Owunyidoro at High Court Extension and Basic Division before he rose to appeal, becoming Deputy Chief Justice and later Chief Justice. Despite my caveat to Parliament against his approval, warning that approving Owonyidolo would be disastrous to administration of justice. And I think in this decade I've been proved right. In age limit removal, constitutional petition number 49 of 2017, Madam Attorney General, consulted with others, in his read judgment, he awarded every petition 20 million professional money except me. He said every petition is given 20 million except Mabirizi. On account that I was not an advocate, I represented myself. In the same judgment, if you read it, and during proceedings, Owonyidolo thanked me for great industry and research. But because he doesn't want me to go far, he denies me the money. He said that I have no use for money. He treated me just like a dog. That was Owonyidolo in Mbale. I managed to access Supreme Court in Presidential Election Petition number 1 2021, Kyagulanyi versus Museveni. Here my role was simple: chase Owonyidolo out of the case because he was a Museveni lawyer. He didn't, like, he does not deny that he's a Museveni lawyer. Owonyidolo turned against his fellow lawyer, Justice Esther Kisache, robbing her files, and up to now, I do not have a full decision in my Supreme Court application number 3, 2021. That is an application for the accused of Owonyidolo. Owonyidolo closed the lawyers out of the Supreme Court, stopped paying Kisache her salary, making her default on her mortgage, reported Kisache to a Weekling Judicial Service Commission, then under another Weekling judge, Benjamin Kabito, over disobeying his directions for him to censor her decision. Owonyidolo says he had to look into what Kisache had written before he delivered them, and for refusing to share with her, he reported her to Kabito, and Kabito said, Museveni, can you appoint a tribunal? And Museveni said there's a tribunal to chase Kisache from there. But the justice is now in exile. The tribunal has been named. So this is a senior lawyer against a senior lawyer, mature people in the 60s. This is what is happening. Now, the law does not require me to study a diploma in legal practice to be enrolled on advocate's role. I have heard many voices telling me to go to Law Development Center so that I can become an advocate. Of course, I may not be wishing to do so, but this has come from judges, senior lawyers, and common people. I think this is an opportune time to teach you what the law says. This reasoning is because of extreme and long-time brainwash that legal practice is an academic affair as opposed to a practical affair. Yet not. The Advocates Act, by the law, has no mandatory requirement of going for a bar course before enrolling someone to the bar, as we have made it, as the lawyers and others have made people to believe. Think about this. What course does an engineer go to be registered? What about a surveyor or a medical doctor? All what is needed is hands-on skills, not full-time teaching. Therefore, even if I'm to be enrolled, mine will not be after going back to a formal school where students are taught my authorities. So you are telling me to go to a school where I read English has my Mabirizi, then you tell me, then you can say how awkward. You are putting us. Hey, you want me to cite myself? then someone whom I defeated or even fears to attend that case marks me and he says you passed. That is nonsense. Now, although Judge Yasini Nyanzi, in the other case I told you, refused to consider our arguments against 22 exams in High Court Civil Division, in Senior Schools number 188 of 2015, Maria Sanibas Attorney General, allow me to produce what I argued on the point that a bar course is not mandatory to be enrolled. I said, Section 7 of the Advocates Act, then, I don't know, I think they have now rearranged them, provide that a person to whom this section applies shall be eligible to have his or her name entered on the roll. Then they list persons who are to whom the section applies. They say, a holder of a degree in law granted by a university in Uganda. A holder of a law degree from a university in Uganda is not subject to regulations because the framers of the Act knew that in the process of obtaining a bachelor's degree in Uganda, such person was exposed to the laws and the legal trends in Uganda, and no further impediments is required for him. This is even supported by the long title of the Advocates Amendment Act 2002, which said that the act was intended to provide for easier access to the Uganda bar. The regulations of the Law Council is mandated to make under Section 1713 of the Advocates Act clearly don't apply to law graduates from a university in Uganda. And I stand by this position 10 years down the road. If the plan is to ease access to the bar, why only apply one theoretical route for admission? This Law Council just hijacked the will of the framers of the Act and perpetuate the admission to the bar of only theoretically cooked lawyers, leaving out practically exposed group. So those who expect me that I will go one day wake up and go to DC to write my authorities, that will never happen. So today's lawyers mostly move in opposite direction from that of citizens. The discussion above reveals that my 10-year journey of rule of law championship has been impeded by lawyers who, in the first place, are supposed to pride themselves in rule of law. Lawyers are supposed to protect and promote rule of law. I have moved and litigated throughout Uganda, Lango, Bugisu, Busoga, Bukedi, Kigezi, Teso, and was low as magistrate grade 1 court like at Chotera. The reality is that lawyers sitting in those courts only sides, on all sides actually, be it judicial officers, advocates, state attorneys, mostly move in opposite direction from that of citizens. Corruption, bribery, arbitrariness, and unreasonableness are the order of the day. Some are professional, but there are a few. Most are rogues, like a chief magistrate caretaker in Chotera Court, who on 11th April 2015 ordered police to force me out of court premises because he had adjourned my criminal case number 64 2015, Uganda versus Mosca and Rugaba, over saying that court-martial ban is unacceptable. So the lawyers, they move, citizens want rule of law, citizens want justice, but most of these lawyers, they just walk in opposite direction. They survive on corruption, bribery. Of course, another citizen would expect, yes, a citizen would expect fairness in courts. But you go to State House, Office of the DPP asks for money. A lawyer in police, by way of CID, asks for money. A magistrate asks for money. A judge asks for money. So essentially, the lawyers actually betray the citizens. Now, rogues have taken up judicial positions. We are reserved for disaster. Since rogues have taken up judicial positions, we are reserved for disaster. When you have lawyers taking up, like, I'm telling you, the magistrates and the judges, when you have thugs take up, in Uganda we say, obo wadde impisi kolachi kusoroza katale impisa yagala nnyo ennyama ate ogiganda esoroza kataleko ennyama. It means agenda kulya buli nnyama y'abantu. So when you bring impisa yehaina, when a hyena becomes a taxman in a meat market, you know what will happen. So right now what we're having hyenas sitting in the judiciary, and we are saying this is causing disaster, and this has been sounded worldwide. I'm going to give you about 3 passages. The one, it says that it is impossible to ensure the rule of law upon which human rights depend without guaranteeing that courts and tribunals resolve disputes free from any form of pressure or interference. Without the rule of law and the assurance that comes from an independent judiciary, it is obvious that the equality before the law will not exist. The courts need the trust of the people in order to maintain their authority and legitimacy. The credibility of the courts must not be weakened by the perception that courts can be influenced by an external pressure. This was an African case in Gongo versus another versus the Republic of Zimbabwe from South Africa, South African Development Corporation Tribunal. Then there's another court saying that the attainment of justice represents one of the enduring promises of constitutional democracy. More problematic for citizens who seek justice is the fact that judges, like Sekana, driven by the lust for power and wealth, often align themselves with the rich and the powerful in society to frustrate the search for justice. This was from Nigeria's author, Okechukwu Oko. Then there's a book called Corruption in the Judiciary. It was written by a Serbian called Dreger in 2004. He said that without a sound and functioning judiciary, there is no rule of law. While things are not in order in the courthouse, the judiciary cannot effectively protect human rights, nor can it perform effective supervision over the executive and legislative power. A poor protection of human rights, life and property, may lead to the appearance of alternative private mechanisms of protection, which usually bring more harm than benefit to society. The simplest is when a victimized individual takes justice in his own hands because he cannot or believes that he cannot get justice in court. And I think here we are now. Another passage says, judicial prestige and authority are at their greatest when the judiciary is seen by the community and the other branches of government to conform the discipline of law which it administers. The rule of law is not enforced by an army, no. It depends upon public confidence in lawfully constituted authority. The judiciary claims the ultimate capacity to decide what the law is. Public confidence demands that the rule of law must be respected above all by the judiciary. This was former Australian Chief Justice Mary Gleeson. So where are we now? The judiciary is behaving in a manner opposite to wishes of the people. And what do you expect? Everyone is going to look on. Council Edison Karuhanga, I have to recognize your presence as well. Although the other side we... There's where I disagree with him, where I call him a lone merchant. He's yet to convince me. Now, as we almost concluding, wealth accumulated by lawyers through corruption will be stolen from their surviving spouses and children. If lawyers sitting in court condemn their fellows unheard, what will engineers do, or even businessmen in Chikobo do? If a lawyer calls in writing his judgment like Sekana do, how will he encourage parties to adopt alternative dispute resolution? If a lawyer is envious of his fellow lawyer getting money for work done or gain political capital from court cases, how will he enforce non-payment of lawyers? Moving forward, lawyers, whether in private practice or public service, must understand that there is a reason why they are not traders. They are lawyers to serve humanity and posterity. A lawyer is not a trader. And of course, among some things when you are spoken, which are important, is telling lawyers every time we go before him that you people, you are not traders. That's why you don't get a trading license. And that's why law firms are exempted from getting a trading license. Because law is not a trade. Law is a service to posterity. You serve humanity, you serve the people. It's not that you are going to be there, that I went there, I bought my maize at 500 shillings a kilo, I'm going to sell it at 1,000. No, it's a service. So the day lawyers are going to understand that they are not traders, is the day they are going to be ethical, is the day a magistrate is going to say, no, I don't want your money, let me look at the law as it is the day Chirwachon can understand that actually he's holding that office in trust for us and not for the benefit of his law firm. Yes. So, they must know that if the public loses trust in the judiciary, they will be jobless first. We shall get alternatives to judges, and people will start going direct to court. After all, what will be mattering will not be arguments, but corruption. A lawyer today tells a client that, you see, for you to win, you need to bribe a magistrate. So the client understands that actually, he won the case not because the lawyer argued. He won the case because the magistrate was bribed. So if it's me, a money lender, I will not come back to you next time. I'll just look for a judge's driver. Or assistant, yes. And say, the other time, counsel was overcharging me. Take me to the magistrate. Because there's no reason why I should hire a lawyer when I can buy a judge. So the dead lawyers are going to appreciate that a dead judiciary makes them jobless. Those magistrates, now there are many. The more confidence is lost in judiciary, we are going to downsize them. Because we shall look at the statistics and say, but how many cases are people filing in Shortera? That there are only 10 civil cases, yet we need one magistrate there. In high court, how many cases are people no longer go to court? They go to witch doctors, they go to pastors, they hire gunmen. Council Edison Karuhanga, was there a backlog during a meantime? Was there a backlog in courts? Why? Because the military would sort it. I demand you, I hire a soldier. He comes with a gun, you pay. Am I creating a backlog in court? So the day you'll understand that actually, even those judges, that when the more they eat, they are corrupted, they accept bribes. They are actually killing their own profession and the future. They are taking their kids to law schools, moreover, to be like them. Their kids will not be lawyers because there will be no market for lawyers. These policemen with guns will be having the market. The faces will be having the market. Yes, because the first can evict you from land. Why should I go to a lawyer to file a suit? I'll just hire a soldier and he comes and beats you around, he goes away. So more importantly, tell them that the wealth they accumulate through corruption will be stolen from their surviving spouses and children by those who can bribe their predecessors in the judicial offices where they would have planted corruption. Because in the end, thuggery brings thuggery. So tell them to better serve posterity. You see, when a judge takes a bribe, the caution, his short-sightedness tells him that when you take a bribe, you shall buy land in Namugongo. So you buy that land, you write it in your son's name, or when you die, they get it. Now, the land grabber also come when you are dead. And finds another judge in the same office and say, I also have some money. Can you make a ruling that the land is mine? He will make a ruling that the land is his. So you understand that the role you have in society is very important to serve the posterity. The more you think selfish, you are actually cutting the tree on which you are seated. So I have served my citizenry role, and I wish I would retire from public rule of law space. Personally, I think I've served my citizenry role, and I wish I would retire from public rule of law space, which has impoverished me, led me to long-term imprisonment, and greatly impaired my health, leading to death risks. Ideally, 10 years would be 2 terms of a president. And I think it's just enough. The only reason we may continue to serve is lack of alternatives, since most lawyers concentrate on being rich, which requires working with rogues. If you want to be rich in legal practice, today you must work with rogues. If you don't work with them, they will not sign your warrant, they will not do what, you will not even win cases. So we are looking forward to grooming more likes of Mabirizi. Yes, we are looking forward to grooming more likes of Mabirizi. And this is Wakafuzi, who is now bedridden and requires your financial support since he spent all his space practice doing public interest. That's why I found him at ICD. He cannot actually walk. The likes of Isaac Semakade, Elias Rukwago, who is currently having ailments. We need judges like Late Kenneth Kakuru, who died under circumstances that consider poison, Professor Chirukubinza Idadi Mwangusha, and Paulo Mugamba, who stood with Ugandans in declaring the age limit removal unconstitutional. It was a very big test to them, but they said no. Actually, it's not here. One time I went into chambers with 7 justices of the Supreme Court, Katrebe and others. It was a confidential meeting, but now they are retired, I need to disclose. I wanted Katrebe out of my case and to Mwesiji. We went there, some quarreled, like Aracha Moko quarreled a lot. But Justice Mwangusha never quarreled. He told him, Mabirizi, we are here for a purpose. We sit at this court for a short while. So we must make sure that long after we have left, people who read what we have written will appreciate that the man who sat here in the name of Mwangusha or whoever had a reason to sit here. So Mabirizi, trust me, we shall do our best. Again, I wanted Katrebe out. But then I couldn't fight more after Mwangusha had. So, but anyway, he said the amendment was unconstitutional and, of course, with reasons. So we are short of litigants in the caliber of Dr. Kawanga Semogede, who was actually not a lawyer. The likes of Reina Kafiri, an lady who later suffered an arrest in execution, of course, awarded in public interest case. Dr. Wanyalale, the Philip Karugabas, Professor Loko Nyango, Sylvia Tamale. The list is not very big, though not exhausted here. Lastly, you need to learn to fundraise. You need to learn to fundraise to these fighters so that they concentrate on rule of law duties without much disturbances from personal expenses. It is extremely challenging to give time to public cases, but also struggle to get money for transport, photocopy, among others. This gives a chance for rogues to compromise fighters. We have lost many fighters, leave alone prison. They have been compromised. They have been good people, but when they can't cope up with poverty, they got compromised. Then the public is here yearning, hey, we want, but munjagala nyo sina sukari. Sina transport. Like the comedians are praying. Mabirizi, why I own a border. So we have continued our fundraising through citizens. On our normal numbers, we know them. 701-881-231 and 78763086. People normally ask them on X. Fundraising is ongoing. Yes, it will continue ongoing because there is a purpose. But why? There are 3 important reasons why we emphasize fundraising. There is a need to awaken citizens that they have a financial obligation towards a better Uganda they deserve. When you want a better government, you contribute. When you go to US, our Iraqi colleagues are demanding money from US. But what happens to those people? They fundraise for their candidates. And the benchmark for you may be to compete for a flag in Republican Party, ODP. They ask you, how much fundraising money have you received so far? So that when you come, you serve the interests of people who fundraise for you, not your interests. Secondly, in absence of foreign donor funding, and where a few available, have conditions on what type of case to litigate. Because the donors will tell you, no, we don't want such type of cases. No, we want this, we don't want this. We need to get money from citizens with a duty to remove an illegal regime. Because Article 3 is, every Ugandan has a duty. So you cannot bank on German funds, US funds, yet actually the rule of law is your duty under the Constitution. That's the reason number 2. Reason number 3 is that rather than give up because of lack of money, it serves posterity better when you call upon fellow citizens to contribute. Because otherwise, if we just remain there, locked with maybe Sentiment and others, we shall just give up. And when do you come? Actually, personally, I was hesitant about to fundraise because and my fears are real. When they fundraise, every person claims that he gave you money, even the one who never gave you. But they say, okay, the percentage are fair. It's our money. It's our money, even when they never contributed. So I thought I could do my role without their money. And I think I did that for some time. But later, we said no. This is a citizen, and this is something which Semaka talked about at Makele. There was a very hard debate about fundraising. But we said we should fundraise because it's a national obligation. So, fellow citizens, I'm thankful to Uganda Society, Radical Nyuba, and President Semakade for this opportunity of the award, and also to address you. So that is my paper to be available. Thank you so much. But before I leave the podium to the organizers, one senior counsel asked me to, I've also seen a statement by Uganda Society about Eddie Mutwe. Eddie Mutwe is called Eddie Wolf. Although the statement calls him Mutwe. Mutwe is a nickname. That man is called Eddie Sevufu. Of course, automatically, detention without trial, or even now. Some of you think that torture is only when they beat you up. But when you read the Prohibition and Prevention and Prohibition of Torture Act 2012, it prescribes what amounts to torture. It includes incommunicado detention. When you keep me somewhere where people don't know, that's also torture. Then when we go to these extremes, shaving someone not for hygienic purposes, dying what, it's torture. But my message was so simple that don't be diverted from standing by rule of law. I've told people that this is provocation. I've told my group that this is tribal provocation. Sometimes you could be provoked so that you act in a given direction so that the other one can understand better how to deal with you. So what I want to tell people that this is a provocation. Yes, illegal it happened. You can deal with it legally. But when you take it to a tribal line, he's learning Runyankole, and then there's how do they teach him Runyankole by force? That is tribal provocation. Personally, I have refused to recognize Twitter posts as binding communication for many reasons. One, I'm a victim of being imprisoned for things attributed to me. Secondly, there's a court decision in Sela Nyanzi, Makadi was a lawyer, where I just sat on your head with that. A Facebook post cannot be proved unless Facebook has proved that actually you posted it. So although I look at Muhoozi posts as bibozi, some hearsay statements, don't take it so serious, because that way you'll be provoked. In fact, in the one before we know, we may end up in a tribal thing which we may not want. Thank you so much.
Wow. Another round of applause. A rather tumultuous journey. We don't take anything for granted. Mr. Malay Mabirizi, as citizens, we take cognizance of your hard work, and we pray that the Lord guide you in your continued struggle. We leave you in the hands of the Lord, and we also pray and make a cry out to the citizenry to join in the cause that Mr. Malay is pushing for. The numbers that he shared are his own, and they are open for fundraising. He has come out clear that it needs a lot more than just his own money, but also because it's a citizenry cause. The numbers that have been shared will be shared once again. The other aspect is that we, as the Uganda Law Society, also as we celebrate him, have a cake that was shared to him. He is going to, of course, also cut it with us after some time. We want to get done with the agenda for the day so that we can proceed. Thank you so much once again. Your speech and your paper was very beautiful. As we are implementing our mandate, like he corrected, we also pray for the support of the citizenry as the Uganda Law Society implements the mandate as specified in the Uganda Law Society Act. Ladies and gentlemen, in the House, as we get to the close of this session, we have with us a senior colleague among us, a very senior lawyer in the profession, who is a member of the Uganda Law Society. He is a litigation and energy law department advocate at the Kampala Association Advocates. He is also a duly nominated candidate in the Uganda Law Society representatives to the Judicial Service Commission. He is a very good friend to the Radical New Bar. He is also a rule of law advocate and a mentor. And with me, ladies and gentlemen, allow me welcome Counsel Ellison Karuhanga for a very short word. Thank you so much. Yes.
No, I had just come to listen and congratulate Mr. Mabirizi on his years. Of course, many people know that Mr. Mabirizi and myself may not agree on everything or even on many things. But I think it's also important that we listen to ourselves, even when we don't agree with ourselves. I heard what he said about about practicing law, and maybe we need to have an interesting discussion on that, and about many things. But I think the strength of a law society is that we are different. Is that someone once said that we are not a blanket, one color, one texture, one size, but we are kilt, many patches, many colors, tied together in a common thread. So although we may not agree much, it is important that we don't agree. I think the fundamental training of lawyers is to disagree. And when we find ourselves always agreeing, we shall have a problem as lawyers. In fact, at the moment, I'm engaged in an exercise that can't move forward because we can't agree. So disagreement is the fundamental lubricant of our profession, and we must cut ourselves with knives and swords that heal, not that leave a permanent mark. So that's why I'm here, to listen to him and to congratulate him on the 10 years of the Law Society has done. I don't intend to speak, and that is why I sat at the door. I intended to run.
Thank you.
Thank you.
Thank you, Council. Your work speaks for yourself, so you can't hide so far from us who you have mentored. So we thank you for your speech. Ladies and gentlemen, I would like to take this honor to welcome the Honorable Treasurer on behalf of Council, who is going to give us closing remarks as we get to the end of this session and wind up everything that has been done today. Honorable Treasurer, you're most welcome to the podium.
Thank you so much, MC. Good afternoon, ladies and gentlemen. As earlier introduced, Isiko Arthur, Treasurer of Uganda Law Society. I send greetings from the Radical Nuba, the Governing Council, the President, Vice President, and other Council members. I would also like to thank the existing present advocates that are with us. I think led by Senior Counsel, Mr. Elson Karuhanga, and other advocates who are present in-house. We also recognize other advocates who are online that are participating in this memorable historical event where, one, we are recognizing the rights of employees, but at the same time, recognizing one of the human rights rule of law journal, Mr. Male, HK Mabirizi. Please give him a hand of applause. I think today I won't say much, but I'll just make a few comments in light of the petition that we have received from the returnees. I want to assure you that we have officially and we have officially received the petition, and we shall accordingly study. We shall study this petition. We shall do the investigations where necessary, and we shall give you the necessary legal backing to ensure that you receive your remuneration. Recently, I talked about the rights of employees. We have been celebrating the International Labour Day, and we are very clear on this, that employees have rights. And I think one of the rights that they do deserve is a right to pay and a right to equipment, to safety equipments to ensure that they can perform the services that they do provide without any, what should I call it, without any damage. In this situation, we see that people from our Ugandans who had gone to Iraq were subjected to a situation where now they are suffering from health issues. I think some of them have hearing impairment, and others have a visual impairment. This is all because probably some people didn't ensure that the gadgets or the equipment that they were presenting to these people were really up to task. And that is why you have a situation where people are here and they are trying to get assistance from Uganda Law Society. We implore the government to, and we shall engage government, especially the right office that deals with taking a labor force abroad to ensure that these people at the end of the day receive the adequate compensation. Mr. Enoth, Dr. Migade Ronald, Mr. Victor Musinguzi, and Mushabe. Baigeds, please, thank you so much for bringing this petition, representing your colleagues to bring in this petition. And thanks for that insight presentation about what exactly happened. I think now majority of the members of Uganda Law Society and the members of the public have a clear picture of what really transpired. You can actually see that they're in a situation where heavy artillery, we talked about the hard caliber, the double barrel and so on, the bombs, how they're exposed to such heavy equipment that can actually cause impairment to limb and to body. So we thank you so much for that. Our colleague, Advocate Obama Andrew, thank you so much for that presentation concerning the plight of state attorneys inside the Uganda police. It remains our stand that all employees require fair and equal pay. And that is the reason as to why you see that when adverts come for a certain position, you see so many people applying, especially when it comes to the judiciary. The payments are different. We all studied the same law, but it is so sad that our advocates who are working in the Uganda police and other sister companies are really getting a lower pay. And yet, initially, there was even a green light to ensure that these people benefit. We can't approbate and reprobate at the same time. If initially they had decided to improve the salary of the advocates in those areas, they should maintain. Such an imbalance only creates discourages performance amongst the employees of such institutions. So we call upon government, especially the Attorney General, because the Attorney General is the chief government advisor. The Attorney General should come out clearly and advise government. Mr. Mabirizi has talked about this issue of lawyer versus lawyer. It shouldn't be now a lawyer advising government that they shouldn't pay other lawyers to the same rate. It is very unfair. What other special service are lawyers in a certain field giving that probably the lawyers in security companies are unable to give? So, Attorney General, please look into that and advise accordingly the head of this country. I think also in light with the practice of advocates, there is now a growing concern amongst so many lawyers that they have done everything to apply for their practicing certificates. They have got the necessary approvals from the Uganda Law Society. In fact, Uganda Law Society, once an advocate makes a payment and whatever service he needs from us, we deliver not more than 5 working days. But we have advocates who have applied and now it's 2 months without a PC. Can you imagine? Your lawyer has applied to get a practicing certificate so that they can ably represent a litigant in court. But to date, they haven't received the practicing certificate. This is only because probably either the office is overwhelmed of the chief registrar with the numerous applications of various lawyers concerning their practicing certificates. And I think this is the time where, as Uganda Law Society, we are making recommendations to the judiciary. One, they should come up with enlarging the validity of the PCs. We have been talking about this. This is not the first time lawyers are talking about enlarging the validity of practicing certificates. We have driving permits where someone can apply for a permit for 3-5 years. I think the drivers here know that. You can apply for a driving permit for 3 years, or even 5 years. So this is something that is professional. Once someone has been professionally approved by the relevant authorities that is able to provide legal services, I think government should look into that and enlarge the validity of PCs. Okay, if this is so demanding on probably one office, let's say the chief registrar, because we see that all the PCs are actually worked on by the chief registrar, Kampala. I think that office may be overwhelmed because the numbers of lawyers are increasing day in, day out. And remember, that office also has to handle other administrative activities of the judiciary. So let's think about decentralizing this mandate. This can actually be done by other departmental offices in the various regions that we have, where we have lawyers and they're practicing in such regions, Western region, Eastern region, Northern region. It doesn't make sense for a lawyer to drive all the way from Arua, Lira, just to come and file an application in Kampala and then start following up. Imagine a lawyer who has been following up for the last 2 months just for a practicing certificate. Imagine that embarrassment where they have to ask you, where is your practicing certificate, in front of your client? And all you can say that I'm following up. The client might even think that you're actually lying. So we should decentralize. In fact, not only decentralize, but we should also digitalize this process. For those who do intellectual property practice, they actually now issue electronic certificates of registration of trademarks. Once you apply, they electronically issue with a certificate. We are seeing government agencies taking that route of digitalizing issuance of certificates of registration. You can actually do a search at the land registry and you get a result instantly. It is done digitally. So this is something that government needs to look at. The resources are available. I think it's just a matter of knowing how to proportion the resources in the right direction. The field of lawyers is a field that touches the core, the foundation of this society. Rule of law, that actually majority of lawyers, if you read the Uganda Law Society Act, rule of law is the cornerstone of Uganda Law Society. We are always standing and ensuring that at the end of the day, it is the rule of law that thrives. Today we have actually sent out a statement in regards to the arrest of Eddie Mutwe. Eddie Sebufu was actually elaborated by Council Mabirizi. That statement is online everywhere. We have actually shared it on our different online platforms. But precisely what we are saying as Uganda Law Society, and we demand, Uganda Law Society demands the immediate release, not only of Eddie Mutwe, but all political prisoners with full transparency regarding their whereabouts and conditions. I think Eddie Mutwe is prominent. That is why it is clearly seen by a majority of Ugandans. But there are so many other Ugandans that are actually suffering the same fate. Kabazuguruka case was very clear on this, that the military court has had no mandate to try civilians. But to date, the civilians are still incarcerated. We are demanding for immediate release, and this is where we ask the Attorney General. The Attorney General, we shall not relent on asking and encouraging you to do what you're supposed to do. Yeah? You are the chief government advisor, and I think in this field you can ably advise the government. We are so saddened as Uganda Law Society that so many things are happening, but we never receive any official communication from the Attorney General. The only official communications we receive from the Attorney General are statements that are saying that lawyers should not be paid, lawyers should not garnish government accounts, etc. But such sensitive matters, I don't know why the Attorney General is being very selective. But we are advising and we continue to advise that the Attorney General should do his job. Please do your job. We are also ensuring, and we shall demand, an independent investigation. Independent, we mean something that is impartial, that follows international standards. Concerning issues that are being raised by so many Ugandans, issues such as torture, abduction, disinformation campaigns, accountability for perpetrators, including high-ranking officials, the Uganda Police and other sister security agencies. I think this is one of your departments where you can actually do better. We need an independent investigation concerning such issues. These issues go to the core, the mandate, the spirit of this nation. I think last time I said that today it is happening to someone, tomorrow it will happen to someone else. It can happen to your sister, it can happen to your brother. You should stand out and demand for accountability. If we as Ugandans don't stand out to demand for accountability, no one will. Don't wait for HK Mabirizi to file a petition, because I believe many are waiting for Mabirizi to file a petition. Please, you can also stand out and ensure that the rights of citizens are protected. And that is where we demand protection of rights, including employment rights. When you talk about employment rights, we're talking about rights to payment. We have our brothers here who are working abroad. They are demanding that they are paid. They are demanding that they are looked after, they got damage in performance of their activities as workers abroad in different areas. We call upon government to ensure that such rights are protected. They talked about the citizens of America getting their payment. It's because the government stood out and was very clear on their citizens that they need to be paid. But our government is silent. It should come out and actually openly make a statement in regards to the issue of paying these people. So as the Uganda Law Society, we are committed and we shall ensure that legal, civic and global support for Eddie Mutwe and all other victims of state violence actually get the legal protection and the legal remedies that are available before them in our books of statutes. I recognize the presence of Mr. Yasin Sentumbwe. Thank you so much for, as you all heard, he's the head legal ideology in the RNB Council. He's in charge of coming up with ideological, some of the things you see are because of Mr. Yasin Sentumbwe. I also want to thank our visitors, the Ugandans who have actually braved. I think they have been here for around 3 hours. Thank you so much for coming to Uganda Law Society. The doors are always open for Uganda Law Society. It shouldn't only be about probably your employment rights. If there are any other violations you think that deserve the attention of Uganda Law Society, the doors are always open. Please feel free. To the students that have actually also come here, I've interacted with quite many. I was at the IU Lawyers Dinner. Thank you so much for showing up. I know you are coming from different universities. I won't repeat those universities, but we thank you because at the end of the day, you are the leaders of tomorrow. You are the people who are going to fill the gaps that are being left by some of our colleagues who are leaving because of either old age or sickness. So we thank you and we appreciate the role that you are playing in the various universities out there. Always feel free to come and join us. Yes, Mr. Mabirizi.
I just want to come in because you are going to be the last. Just wanted to comment something on the piece.
Okay.
My observation is one: why are they delaying to issue pieces? Because they think decentralization only applies to creating high court statutes, but under the law, the issuance officer, the issuing authority of that PC is a registrar. Now, what's the work of deputy registrars spread across the country? It should be that wherever there is high court, there is a deputy registrar. The advocates within that statute should go to that registrar of that statute for their practicing certificates. Because the colonialists made it that there was one high court in Uganda at Kampala. So at that high court, there was a person judge and a registrar to allow people to practice in that what? So if there is a high court in Arua, why doesn't a registrar at High Court Arua license law firms which are within the statute? I think that should be the thing to be advocated for by Uganda Society. You don't just put up registrars to sign criminal summons, to sign prison warrants. Actually, the registrars, because under the Civil Procedure Act, a registrar includes a deputy registrar. Yeah. So they should be able to issue pieces in RIRA in Iganga. Yes, because this is business. You cannot tell your client on 1st April that I don't have a PC. He will say you're a quack lawyer, yet you are not. That's what I wanted to point out, and so that you make it very important that these statutes should not be, they should be made to work. Yes.
I think that even sheds more light. Yeah, what instances are the registrars in those areas? Yeah, I think you have raised a very pertinent issue. The judiciary is listening. They always listen. They always contact us, and they believe the judiciary will take action on this issue of decentralization of the mandate of the registrar. I think now that is what we always talked about, decolonization. Let's stop living under the colonial times where we only had one registrar or one high court. Those are things that we need to really do away with. So I will end by thanking the organizing committee. There is an organizing committee that ensures that this activity goes on as planned. Thank you so much. Our service providers who provide the services that you are seeing, the online services, we thank you so much for ensuring that this activity happens successfully. Members of the Secretariat, your role is always appreciated by Council. We really thank you for spearheading and ensuring that this happens on a weekly basis. I will end by quoting the President of this country, who said on the 29th of June 2022 that cases of illegal detention, torture, human rights violations will not be tolerated. Torture is not only wrong, but unnecessary. To all the security state actors, from the highest to the lowest, torture is unnecessary. I think the President has always been clear that if he was probably killing some of the opposition leaders, like Kizza Besigye, it could make Kano Kizza Besigye a hero. People would always crave for Kano Kizza Besigye. So in such a situation, we remind the security agencies to comply with what the head of state made a comment about in regards to torture and human rights violations. I thank you so much for listening to me. I think at this juncture, I'll invite the MC. We shall have a photo moment. He'll advise on how to. We invite questions. If anyone has a question about what has been presented today, please feel free. There is a microphone that is moving around. To our panelists, you can actually use these desk microphones. You can activate and.
I will not stand up because I've got a problem with my leg and the back. First of all, I thank you, members of the RNB, fellow veterans, law students, I think Uganda and the world at large. Thank you for throwing your hand to us when we called out. Yeah, and I'm being moved by what I'm seeing on the wall somewhere. Was like decolonization. Brothers and sisters, we went to the war zone and worked. That was a job or a service to humanity requiring a lot of valor. We served the United States and coalition forces in what they told us that was a war against global terrorism, that the terrorists were being a menace against a civilized world. We did our best. We protected people like Prince Harry. We protected the United States Marine Corps. the Navy, and everybody. We protected President Joe Biden. By then, he wasn't president yet.
Vice President.
We protected President G.W. Bush Jr. But do you know what we are getting in return? It's not only 3M earplugs that we are being left out or given a word like black stay back. I have all the right to believe like that because like I've been hearing of stuff like rogue justice. This seems to be rogue justice to the Ugandans who served the United States, whatever, military in Iraq and Afghanistan. Without fear or favor. When it comes to DBA, compensation for any illnesses that may have developed long after or shortly before, or after service in Iraq and Afghanistan. We are being given peanuts, a mere $10,000 US. Can that keep me or try to indemnify me or compensate me in any way to be at least somehow similar or like to a picture of my former self? No. That is called DBA. But we are being cheated. Some of us, it's being delayed, that end up dying even without getting anything. We even lack money for medications or getting proper medical attention. What they had promised us, as per the contracts, it didn't materialize. None of us was ever taken to Germany, that is Ramstein, or Kuwait, before coming back to Uganda, our country of origin. So we are here with a lot of sicknesses, some already diagnosed, some not yet. Symptoms have shown, and others have not yet. People are dying. What's the American government doing? This is happening under the eyes and the nose of the CIA and FBI. Please, America, America, America. America, America, America. Human rights, human rights, human rights. Our human rights and workers' rights have been violated and trampled over. Then it comes to 3M earplugs. It's like the laws or the rules of the game are being extended every other new step. We are all eligible claimants of the 3M earplug case or litigation because they told us the qualifications were, or the requirements were, if you had used the Kayev 2, that is Combat Armed Earplug version 2, between 2005 and 2000, something like what? 15? That was enough requirement. Then later on, they're going to extend that you have to show, to give some 2 audiograms, one made shortly after deployment downrange, and the other some few years after. These are just tricks. So, we are calling on the American government and whoever is concerned, with the help of our colleagues, CIA, FBI, former Marine Corps, Navy, Mossad, MI6, wherever you are, please, people who served alongside you are being cheated by some crooks in the United States. This is not government policy. No, it's just an illness in American society. Please save us from this rogue court and rogue justice. Thank you. It's not a question. Please. It's a cry.
Thank you so much for the cry. It has been heard loud and clear. It is a part of the petition. Honorable Treasurer, without further ado, There is a question online coming from one Shalva, who is asking the question, who is an eligible 3M earplug? Who is, okay, he's asking for, I think, the eligibility towards the compensation, which of course can only be answered by themselves, but I think within a minute, because I think we have said it all. And the gentleman who has been crying has also given us, he has spoken into the eligibility, which for our own sake and knowledge was the use of the earplugs, regardless of the nationality. But here we go, just within a minute.
Thank you, sir. Thank you, sir. With who is, the question goes, who is eligible 3M earplug to be set, who is eligible to be settled within the 3M earplug case or program? According to section 7, according to Article 7, section 7.1, 1 to 3, goes for the defendant. I'm not good in laws, Mr. Mabirizi. I agree with you, sir. For the defendant to pay, the defendant was meant to pay a threshold or to pay the administrative costs or expenses if the threshold of 99 participation was not met or was not to be what? Was not to be accumulated. How does it go? That these people, when they saw that they had no numbers to make that what? To make that reach, all of that compensation, they came down to Uganda. They gathered our papers. They certified that we went to the war zone. They certified that we were suffered. They certified that we were traumatized. We got sick. These are people who lastly dropped us out. But in the very beginning, they explained thoroughly well that we were eligible because they got our papers and they got that threshold of 99%. So it was just a walk away win, according to the what? To the settlement program. Thank you. Mr. Mabirizi, thank you for the minzani. At least it's balancing. I like your way. As we, Ugandans, humanitarian and terror team, we sat down as we thought about the people who were dying there due to terror. We came out of a resolution saying that we have to bear this condition, to spare those lives, the human race, to spare their property. And it had even reached here within Lugogo, something. The blast. It is to why we came up and we said it is now heading toward to our country. As the globe, it is already suppressed it. So we went into that, and really we made it professionally. Thank you, sir. I appreciate it.
I want to clarify on this question a little bit. Who is an eligible 3M earplug settlement program? Claimant. It's very simple. In the background, in the beginning of the settlement, they included almost everyone: U.S. veterans, commercial users, and other foreign nations. So we fall under the foreign nations. So whoever used this gadget automatically qualifies to get the compensation. So we wonder why the American courts decided to put up such kind of requirements, which are kicking out Ugandans and many other nations, not only Ugandans. They used our papers to get the 98% percentage that was required for 3M company to release the settlement. Once they got the settlement, They set up requirements. For what? Okay, medicals were required, it's okay, to check the status of your illness. But if I have no medicals, you'll still pay me. If my medicals show that I'm severely injured, then you give me more money. That's how it should be. But if I have no medicals, and I have all the proof of use of the gadget, you pay me the minimum you can pay, but you don't kick me out. So this US government should come out and the US courts and clarify this issue. That's all we are requesting.
Thank you very much. This discussion will never end if we do not give these people the time that is due. We want to appreciate your time with us, and we are surely, as the Honorable Treasurer said, we shall look into the matter, investigate it, and take further action. So, may you be rest assured that something is going to be done. Honorable Treasurer, I would like to pass the microphone back to you.
Thank you so much for the participants. The clarifications that have been made by Mr. Enoth and Dr. Migade concerning the questions that are being raised online. I think at this juncture we shall will guide on whether it is cake cutting or photo moment. You can advise. Okay, at this juncture I'll invite our invited guests to come and partake in this photo moment.
Yes, there's always a session of a photo moment with the guest speakers and the host for purposes of record. We'll invite all the guests across to come over, take a picture